presence for this national level workshop. Also, I
मॅडम हे बंद करू नका.
काय बंद होते सर? हॅलो.
Here is a technical issue, network connectivity issue from my side. So it was from my side, no problem. You can proceed.
Okay, sir. Subsequently, I would like to hearty welcome to the chairperson of this national level workshop, Sri Venkatrauji Anandrao Kadam, who is the former MLA and president of RSPM Sompet. Welcome, sir. Subsequently, I would like to hearty welcome to Mr. Govindraoji Deshmukh. He is the secretary of Kamadhenu Seva Bhavi Sanstha, Vasundhara College, Ghatnandur. Actually, presently he is right now he is not present with us, but he has sent his best wishes to run this program smoothly. Thank you, sir, for your best wishes. Subsequently, I would like to hearty welcome to Shri Parmeshwar Rajabhau Kadam. He is the president of HSPM Sonpet. Also, I would like to welcome to keynote speaker of this workshop, Dr. M. Bechkar, sir. He is the principal of Shri Kumar Swami College, Ausa. I would like to welcome to the chief guest of the valedictory session, Principal Dr. V.D. Satpute, sir. He is from late Ramesh Varpudkar Arts, Science and Commerce College, Sonpet. Currently, I would like to hearty welcome to the chairperson of this valedictory session, Principal Dr. H.P. Kadam sir from Sri Pandit Guru Pardikar College, Sirsala. Also, I welcome to Assistant Professor Vikram Dhanve sir. He is the IPSC coordinator of Sri Pandit Guru Pardikar College, Sirsala. I would like to hearty welcome to Dr. Mukundraj Patil sir, who is the IPSC coordinator of Ramesh Varpudkar College, Sonpet. Also, I welcome to Dr. Anand Jadhav sir, Dr. Vittal Jaibai sir, Dr. Samne sir, Dr. Turme sir, and my all colleagues from Vasundhara College, Ghatnandur, as well as from Ramesh Varpudkar College and Pandit Guru Pardikar College. Welcome to all the participants. And due to whose free hand cooperation and technical support, this program is going to run very smoothly. I welcome to welcome to Assistant Professor Godbole sir in this webinar. And not last but least, the backbone of this webinar, I would like to welcome all the dear participants in this one-day national level interdisciplinary webinar on intellectual property rights, introduction, awareness, and registration process. What I request to Dr. Jadhav Anand sir to give a brief introduction about this national level workshop. So please, Dr. Jadhav Anand sir is from Sri Pandit Guru Pardikar Mahavidyalaya, Sirsala. Please, sir, over to you.
Thank you, ma'am. Thank you very much. Am I audible, sir?
Yes.
Yes, you are audible, sir.
Okay. Thank you very much. First of all, I heartily congratulate and wish to all the coordinator belongs to three colleges and the principal of all these three colleges who are jointly organized today's national level interdisciplinary virtual workshop on intellectual property right. So I wish and heartily congratulate to all of these members. Today, the internal quality assurance cell of Sri Pandit Guru Pardikar Mahavidyalaya, Sirsala, IQAC of late Ramesh Varpudkar Arts, Science, Commerce College, Sonpet, and IQAC Vasundhara Mahavidyalaya, Ghatnandur, jointly organized today's activity. And this activity is regarding to the new concept, intellectual property right. Actual, this concept is not too much familiar for us. Those peoples and those colleges belongs to the such a remote area, or I say a rural area, because this concept is more familiar to such places which are situated, such colleges which are situated in metropolitan cities, or where is the industrial areas, or where is the ICT parks. In such areas, the many peoples are more familiar and aware about the intellectual property right. So it is more necessary for us to know what is this concept intellectual property right. According to that aim, our three colleges are come together and organize the such activities, and its aim is very beautiful, and I hope that this webinar becomes more fruitful for us, because this concept intellectual property is the product of human intellect, which includes the creativity of human mind. It includes concept, invention, industrial models, trademarks, songs, literature, symbol, name, branches. Such a lot of things includes in this concept intellectual property. We are, as we are working in the field of academic, we are academician. As an academician, we know the one concept about it we are familiar, which is the copyright, because this intellectual property included measure of four types, which are, out of that four, copyright is one, and we are more familiar about the copyright, because this copyright it covers a tangible form of the creation and original work. For example, art or music or drawing or our writing essays or prose, poetry, all these things are included in this copyright, because copyright's owner has the exclusive right to sell, publish and reproduce any literary, musical, dramatic, artistic work created by the author. We know this one copyright, one type of this intellectual property, but other than copyrights we have other type also, like a patents, trademarks and trade secret. All these types, absolutely our today's prominent chief guest and keynote speaker, Dr. MD Shirsak sir, who is the director of RUSA, Dr. Babasaheb Ambedkar Marathwada University, Aurangabad. Absolutely, he will focus and introduced on the IPR and its awareness. And we have the another chief guest also, Dr. M.M. Bedkar sir, who belongs to Sri Kumaraswamy College, Ausa. He is working as a principal, and he will be also focused on the type of intellectual property and what is the registration process of this intellectual property right. Now this concept nowadays it become very important, because our Indian government also established the commercial court especially for the intellectual property right. This commercial court in India, it passing by the new act in 2015 and established the new court for such intellectual property right. According to this intellectual property right, we will get very intellectual personalities for this workshop. And I think I stop here with this brief introduction of this today's national level intellectual virtual workshop. And I feel great gratitude towards the all principal of these three colleges, and I wish for the coordinator of IQAC belongs to all these three colleges, and I feel thanks who given me such a opportunity to introduce the present activity. Thank you so. very
Thank
much.
you, sir. Thank you. Your brief introduction about this national level interdisciplinary workshop on intellectual property rights, its introduction, awareness, IQC Guru Pardikar Mahavidyalaya Shirsara, to introduce our chief guest as well as the keynote speaker, Dr. M.D. Shirsar, sir. Please, sir, over to you. Sir, you are not audible, sir. Dhanvesh, sir, you are not audible.
Yes. Yes, ma'am. Very good morning, fraternity. On the behalf of all this trio, we are here witnessing this new invention, new innovative program, that intellectual property right, which is a major concern issue nowadays. Friends, today we have among us highly elevated and dignified personality that who is known as one of the leading scientists in physics as a keynote speaker, Professor Mahendra D. Sirsar sir, who is known for his invention in physics. Whatever is going on nowadays in the discipline of science, especially in physics, it is due to the contribution of Professor Mahendra Sirsar sir is quietly significant. Dr. Mahendra Sirsar sir is presently working as a professor and would be a senior professor soon in the Department of Physics. He is a dynamic person who play a dynamic roles at the university department. Now, currently, he is working as a director of RUSA for Advanced Senior Technology and director of Kaushal Kendra and head of Department Electronics of Dr. Babasaheb Ambedkar Marathwada University of Aurangabad. He has shouldered several other administrative responsibilities at Dr. Babasaheb Ambedkar Marathwada University of Aurangabad as a registrar during 2015 to 16, director of incubation and innovation and linkage, director for internal quality assurance cell, and the director for academic staff college, Dr. Babasaheb Ambedkar Marathwada University of Aurangabad. And simultaneously with, he was a head of Department of Physics during 2013 to 16. Professor Mahendra Sirsar sir is one more, he has credited several patents. He had credited nearly about 7 patents during this time. He was a postdoctoral fellow and visiting scientist at Department of Chemical and Environmental Engineering, University of California, Riverside, during 2007 to 9, as a visiting principal fellow at University of Wollongong, Australia in 2006, visiting professor at Hanyang University, South Korea, and National Taiwan University of Science and Technology in Taiwan. It shows us that Professor Sirsar sir is having such a kind of caliber, and especially about this scientific terminology, as we know that as a property is a bulk of issue for certain people till the 20th century, but nowadays intelligence, it's become a property. After late 19th century, it's become an issue how to just measure and how to cope with this property, intellectual property, and later on that concept have been coined out. As this concept intellectual, I think this Professor Sirsar sir is intellectual one who can easily just elaborate all these conceptual terminologies of intellectual property, right? Professor Sirsar sir has 32 years of teaching experience, research, innovation. He is having around 9 years of administrative responsibility. He has 211 research publications of his credit, out of which 143 research publications from Scientific, Scopus, and Web Science Index State Journal, Peer Reviewed Journal, and 68 from national peer reviewed journals. His high index is 32 and I10 index is 93. His work is cited for 3,293 times. At that time, his scopus is 2,453. Citation 27. It means, and he has credited 7 patents in his credits. He has successfully supervised 19 PhD and 5 postdoctoral scholars. He has undertaken 25 major research projects at national level with total grant of Rs 17.12 crores from various funding agencies. He has played pivotal role to establish Deen Dayal Upadhyay Kaushal Kendra, Center for Vocational Educational and Training at Department of Electronics, and started BHOK, MHOK, and MSc to impart skill-based education in areas of industrial automation and automobile technology. Professor Sirsat has established Center for Advanced Senior Technology for the development of sensor with state-of-the-art facility in the area of material synthesis, characterization, and device fabrication. He played pivotal role in the capacity of IQAC director during 3 cycle of NAAC accreditation of Dr. Babasaheb Ambedkar Marathwada University, Aurangabad, to secure A grade with 3.22 CGPA. So it is a really matter of immense pleasure for all of us that we have such a towering personality as today's resource person. So this is the brief introduction of today's keynote speakers. Just it is beyond, his stature is beyond all these words. So I welcome to the today's speaker, Professor Mahendra Sirsat sir, and thank you.
Thank you, sir. Thank you, your brief introduction. Actually, it is a long introduction with such an expertise. He has a lot of experts in various types of areas. Already many times we have met, Sirsat sir, we have many times met, and I have attended your many webinars, which belongs to the AQR and the NAAC. So I know your expertise and your talent and intellectual. So I heartily welcome to Dr. M.D. Sirsat sir, Director of RUSA, Dr. Babasaheb Ambedkar Marathwada University, Aurangabad. So I request to sir to formally inaugurate this workshop and as well as to deliver address to the gatherings. Thank you, sir. Please,
Okay.
over to you.
Thank you very much, madam. And thank you very much, Dr. Vikram Dhanve sir, for a very elaborative introduction. Respected chairperson of this national workshop on IPR introduction, awareness and registration process, respected Venkat Rauji Kadam Sahib, the another special guest of this function, respected Parmeshwar Kadam Sahib, respected principal of all 3 colleges, Dr. H.P. Kadam sir, who is principal of Pandit Guru Padikar College, Sirsala, Dr. V.D. Satpute sir, who is principal of late Rameshwar Warpudkar Arts Science Commerce College, Sonfet, and Dr. A.Y. Dalve sir, principal of Vasandhara College, Ghatnandur. All IQAC coordinators, Dr. Vikram Dhanve ji, Dr. Mukund Patil ji, Dr. Alka Deshmukh madam, all respected participants, and most importantly, respected Dr. Bedkar sir, who has, I think, recently joined, who is another expert and principal of Kumaraswamy College, Hausa. It gives me an immense pleasure to be part of this activity. To begin with, let me congratulate and appreciate all three principals and IQC coordinators of three colleges and all the backbone, like those who are involved in thought process of organizing this kind of workshop, which is being jointly organized by three different institutions. Because organization of this workshop itself is one of the very important steps that you have initiated. Moreover, as it is mentioned by I think Dr. Deshmukh, Anand Deshmukh ji, right in the beginning, that many a times, like since because IPR is not a new term, truly speaking, but still, as far as the rural area colleges are concerned, as far as the teachers who are working in this kind of colleges are concerned, they may not be aware. Although we know NAC has made it mandatory. If you look at the earlier guidelines of NAC, the guidelines which were there before 2017, or even in the beginning phase of this revised accreditation framework as well, lot of emphasis was given on copyright and patent. But unfortunately, later on, during due course of time, the both aspect have been removed from the assessment criteria as far as the colleges are concerned, because now we are going to have separate guidelines for UG, PG colleges, universities, and autonomous colleges as well. But forget about and moreover, at the same time, nowadays it has become mandatory for all the colleges across the country to get themselves ranked under NIRF ranking, which is National Level Ranking, because nowadays that has been linked to funding as well. So if you are having good amount, like good ranking, at least you have participated based on your ranking and based on your NAC assessment and accreditation grade, you will be eligible. Like your eligibility is going to be decided to get various sort of funding, which starts from research innovation, infrastructure development, and other grants as well. Therefore, if you look at the NIRF guidelines, again, they will be asking what kind of IP you have, what kind of intellectual properties the respective college is going to have, which starts from patent and copyright very prominently. It doesn't mean that this IP consisting of only two important properties, but these two are very prominent IP as far as the academic fraternity is concerned. And therefore, but my concern is, forget about NAC, forget about NIRF. It is going to be a wonderful opportunity for all of us. All of us, what I mean is, all teacher fraternity, and if at all the students are attending this workshop, for them also this is going to be a wonderful opportunity to make us ourselves rich, because this is going to be a wonderful opportunity for us to stabilize our economy. Forget about India's economy, but stabilize economy of, first of all, like I'm going to have a very stable financial. I mean, I'm going to have a very. I'm going to have a financial stability if I start earning some money through this IP. And same thing is like if I become financially stable, I'm sure my college is going to be financially stable, my state is going to be financially stable, and at the end of the day my country is going to be financially stable. And therefore we need not think too much ahead. First of all, let us focus on our own financial stability, and this is going to be a wonderful opportunity for all of us to have the financial stability. And therefore I once again congratulate and appreciate all three administrative officers, I mean, principals of all three colleges, and IQC coordinators and their team for coming up with this idea. I will be speaking at length in my keynote address. Before I start my keynote address, I hereby declare that this workshop has been inaugurated. And if should I take a break, or should I start straightway my keynote address, sir?
You can go for keynote address, sir.
Okay, thank you very much, sir. So I'm going to share my screen. Okay, I'm sure like my screen must be visible to each one of you. Am I right?
It is visible, sir.
Yes. Yes.
And today I will be speaking on intellectual property right, importance. In fact, because I have gone through the brochure and I came to know that the second speaker, Dr. Bedkar sir, he will be speaking on types of IPs and some writing aspect as well. And moreover, like whatever time is allocated for me, I won't be able to. But this presentation consisting of all those aspects. Let me see whether I can reach that point. Otherwise, I will be restricting myself up to importance and awareness creation as far as IPR is concerned. My friend, to begin with, let me tell you, as I mentioned earlier, this awareness is very, very important. The reason being, let me tell you, my friend, forget about patent. I believe that even patent also, I believe that in our colleges, not only I'm not talking about the colleges of metropolitan city, I'm talking about the colleges of the rural area. There are many students and faculty members, they have very, very innovative ideas, extreme high level of innovative ideas, and they are doing it. But unfortunately, since they are not aware, as they are not aware, somehow they are not able to, somehow they could not file their patent, and as a result of that, they don't have patent on their credit. But I know like there are many teachers, they must have filed patent as well, even from rural areas as well. The second aspect is as far as copyright, which has already been mentioned by the speaker right in the beginning, that we are familiarized with, we are well familiarized with copyright. But let me tell you, my friend, although we are familiarized with copyright, but unfortunately, coordinator, can you please take care of background noise? Hello.
Hello. Yes, sir.
Thank you. Kindly, I would appreciate if you could mute all other participants so that there won't be any disturbance in between. If possible, kindly do this. Thank you. Thank you very much, madam. So I was talking about copyright. If you look at first of all, let me finish my perception about patent. As I mentioned earlier, there are many teachers and many students. They are having very, extreme level of innovative ideas. Like one of those ideas could be, there are many people I have seen, many teachers I have seen. I have visited many remote colleges as well, and I have seen their all together innovative experiment they are doing with students. But unfortunately, although they are doing those innovative experiment, but they are not able, because since they are not aware, they could not get any recognition out of this. Just they don't, they are, because it is just because of lack of awareness. And similarly, I was talking about copyright. There are many teachers in affiliated colleges, and even like which include metropolitan cities and rural areas as well. There are many teachers who are having a huge number of books on to their credit. Although they are having, every teacher, like particularly social science teacher, they are having huge, like every teacher will be having at least 2 or 3 books to their credit, and senior teachers, they might be having more than 10 books to their credit. But if I start asking them question that how many of those books, because they know like every book is having copyright, but that copyrights belongs to either that the publisher or somebody else. We don't have that copyrights, we don't have that rights with us, right? Because the reason क्या है? Because unfortunately हमारे teachers क्या करते? Because let's say I'm a teacher from affiliated college or some college, right? Like when some publisher comes to me and if he is ready to publish my book without charging any charges, I will be happy to deliver all rights to him. क्योंकि वो अगर मुझे बताता है कि सर आप मुझे किताब दे दीजिए, आई एम गोइंग टू पब्लिश योर बुक एंड यू नीड नॉट पे सिंगल पेनी, आई विल बी वेरी हैप्पी पर्सन, राइट? लेकिन हमें ये पता नहीं कि वो जो बंदा है, once we provide right to him, but he is earning crores, I mean not crores, but he is earning substantial money out of that. हमें पता ही नहीं है. We are least bothered because we are very happy. वो 10-15 copies 100 copies हमें दे देता है, we are happy with that. But truly speaking, at the end of the day, जब आप आगे चलेंगे तो आपको पता ही नहीं रहेगा कि how much money he has earned out of your intellectual property, and we are happy. मुझे पता है जब when we were doing NAC accreditation of my university, I was very happy to see that many of my teachers, they are having books, and I thought like I will be having huge number of copyrights from my teachers. When I started asking, I came to know that there were very few people who were having rights to their credit. तो ये क्यों होता है हमारे पास? It is just because of awareness. ये awareness अगर रहा, और इसमें कोई बड़ी बात नहीं है. It's not like filing, copyright application, submitting copyright application is not a big deal. It's not only you, it's not only rural area. Same thing, like this is applicable to metropolitan city as well. This is true for me as well, because I know, because I drafted first book during 2003, and that was given to Annamaya publisher, and he said like, we are going to provide you some royalty, but let me tell you, my friend, we are still waiting for royalty, because copyright is, he has copyright with him, and we are still waiting for money. So this is happening with every teacher. I'm not blaming anybody, but this includes me as well. This is what it is happening in our teacher fraternity. सभी लोग हम ऐसे ही करते हैं. We are least bothered. लेकिन ये awareness अगर हमें होता, thanks to NAC रिवाइज जो 2017 से रिवाइज एक्रेडिटेशन फ्रेमवर्क शुरू हुआ था, वहां से ये सिलसिला शुरू हुआ था. लोगों ने काफी अवेयरनेस वर्कशॉप ऑर्गेनाइज करना शुरू किए. People started, thinking in this direction, and all of a sudden NAC ने उसको विड्रॉ कर दिया. तो हम फिर से स्लो हो गए. हमें लगता है कि अभी क्या जरूरत है. NAC has already withdrawn that requirement. Only universities, even university maybe they are not going to ask patent. Those who are published, they are asking only granted patent only. But earlier they used to ask how many patents granted, how many patents published, how many patents submitted, how many copyright you have. That has been removed now because of one or other reason, unfortunately. But still in NRF, जैसे मैंने बताया कि NRF में still NRF is going to ask you like what kind of IP you are having, whether you are from college or university. So, but my submission would be, forget about this ranking, forget about NAC assessment and accreditation. हमें हमारे awareness के लिए, हमारे बच्चों के लिए, क्योंकि हम टीचर ने तो ये सोचना चाहिए कि now, okay, fine, I have, let us say I am on the verge of retirement. Lekin whatever, the intellectual level I have achieved now, I may not have property with me. I may not have IP, register on my name, but I know how to register. I have, for one or other reason, I got that exposure. It would be my responsibility कि मेरे जो बच्चे हैं, मेरे जो student है, जो नया generation है, उनको aware करूँ, उनको बता दूँ कि कैसे इससे it's not only credit, but कैसे इससे पैसा भी कमाया जा सकता है. So that kind of awareness need to be done by each and every teacher. And in that aspect, truly speaking, this kind of workshop is going to be very, very important. So in what I'm going to do is during this, like 1 hour span, I guess 45 minutes to 1 hour span, I'm going to share my experiences. ये कोई typical lecture नहीं होगा. I'm going to share my experiences. So while sharing, I need to take help of this PPT so that I will be able to communicate. I will be able to reach you. Okay. So let me tell you what this IP is all about. What this intellectual property is all about. So before that, हम ऐसा करते हैं, let us disclose what kind of property we have with us. So let me start with the kind of property which usually we have. Let us disclose that. So we have some kind of fixed property, immovable properties like land, we have flat, we have bungalow, right? And we have some portable properties like we have smartphone, two-wheeler, four-wheeler, furnitures, etc., etc., right? This kind of properties is nothing but a tangible property. Why it is called tangible properties? Because this can be touched. This can be like, you can have tangible properties, means the properties which can be sensed, which can be touched, right? This is what we call a tangible property, and owner enjoys exclusive right over the same. So as far as my plot is concerned, I'm going to enjoy the full right of that property. My land, flat, bungalow, forget about the fixed property, but like movable, portable property, like I'm a four-wheeler, but I will always like to ensure that the four-wheeler is on my name. जैसे कि मान लो अगर मेरे बगल में कोई मुझे प्लॉट लेना है, and then somebody ask me, okay, fine, चलो हम बैठते, मैं आपको लीक कर देता हूँ, आप मुझे 10 लाख रुपए दीजिए. So we don't trust him. We always ensure that we will go to the register office and we will make sure that I'm going to have the exclusive right. So as far as these tangible properties are concerned, we always ensure that we are going to have exclusive right. But let me tell you, my friend, there is some intangible property as well. We are least bothered about, truly speaking, intangible properties. The property represented by a product that is outcome of human mind, intellect and creativity. जो हमारे दिमाग से निकलती है, जो हमारे creativity से निकलती है, what that product is nothing but the that product is that is a kind of property which include invention, which include innovation, which include original design, trademark, artistic creation, जैसे कि कविताएं लिखनी है, कुछ किताबें लिखनी है, right? कुछ अगर कोई गाना अगर खुद कंपोज कर रहा है, right? And which include innovation, as I'm going to tell you later in due course of time, difference between invention and innovation as well. This kind of property is nothing but intangible property. This intangible property is nothing but intellectual property. Intangible means the property which cannot be seen, which cannot be, like touch upon, right? That kind of property is called as intellectual property. But let me tell you, my friend, this is also asset. Like हमें ऐसा लगता है कि जो मेरे पास मेरा बेंगलो है, this is asset. But at the same time, whatever creativity you have, whatever intellect you have, that also going to be a kind of asset. We don't trust, but unfortunately हमें उसके ऊपर भरोसा ही नहीं होता है. Although we are teachers, but हमें उसके ऊपर भरोसा ही नहीं होता. हमें लगता है कि no. But truly speaking, it's not only like only having understanding about this intangible property is not going to serve the purpose. We need to have some sort of means. There should be some means, rather legal means, that can be used to safeguard these assets. So whatever assets we have, whatever properties we are going to have through this creativity, through our intellect, we should have some kind of logical means to safeguard this property. And the property right to safeguard this asset to the owners or for the owners is nothing but the intellectual property right. So this intellectual property right came into the existence long back, right? So we need to understand now, like, although since we are generating this kind of property, we are now aware that this property is being referred as an IP, intellectual property. We need to understand now how to get the exclusive right on this property. And therefore today my deliberation would be how to, like, creation of some sort of awareness for this intellectual property. So let me quickly tell you the difference between invention and innovation. Whenever we are talking about invention means creation of product or introduction of process for the first time. Like whenever you are first time giving some product, whenever you are product or process, it need not be product every time, it could be process as well. So if you are proposing that process first time, if you are inventing, if you are developing that product first time, that would be referred as invention. But as far as innovation is concerned, innovation means whatever existing product or process you have. So whenever you are suggesting some sort of improvement or significant, like whatever the improvement you are having, that is going to be significantly affecting day-to-day life of human being. So if that is the case, that can be referred as innovation. But truly speaking, my friend, nowadays this concept, this was the old definition of innovation, the improvement or significant contribution to an existing product or process. इसका मतलब ये है कि जो हमारा existing product है, process है, उसमें अगर हम significant improvement अगर suggest करते हैं, that can be treated as innovation. But nowadays in the present era, the definition of innovation has been substantially modified. Nowadays, like, it's not only like improvement, it's not only improvement. If that improvement is going to be useful for some mankind, some cross section of the society, then only that can be referred as innovation. So next step was, it's not only innovation. If you are proposing innovation and if you are not suggesting any cross section, if you are not suggesting that this is going to be useful for some cross section of society, that will not be, that innovation is not going to be useful. Later on, nowadays, it's not only useful, like, again, like, it should be useful, and at the same time it should have some application. I mean to say, it should generate some sort of wealth as well. So unless and until whatever improvement you are showing, unless it has some the financial outlay, financial outcome, and unless it is going to be useful for some society, right? That can never be referred as innovation. And therefore, whether it is invention or innovation, these three properties are going to be very, very important. It should be novel, it should be non-obvious, and it should have industrial application. So whenever you are talking about patenting, if you really want to patent your idea, in that case, whether it is invention or innovation, it should be novel, it should be non-obvious, and it should have industrial application. In due course of time, I'm going to tell you how to test the test of novelty, how to test the test of non-obviousness, and similarly what the industrial application is all about. But to begin with, let me tell you some important invention in since many days. Like Thomson Edison, we know, like this is like he has developed electric bulb well back in 1879, in 19th century. Alexander Graham Bell has invented a practical model of telephone in 1885. These are some of the important milestones. Let me tell you, Galileo Marconi rather, he has invented first radio in the year 1890. Wright brothers have invented the world's first successful motor operated airplane in 1905. So these are the important, but there are many people, there are many milestones, but I thought let me tell you some examples of some invention. There are some people across the country, this slide describes the individual contribution. This has nothing to do with patent. This has nothing to do with the copyright. But this, like whenever we are talking about tabla, we always remember Ustad Zakir Hussain. Whenever we are talking about painting, we always remember M.F. Hussain. Whenever we are talking about singing, there are many singers, but Lata Mangeshkar has been like one of the very, very prominent singer of this century. Musician Rahman, and missile, whenever we are talking about missile, APJ Abdul Kalam. So these are some of the individuals who has significantly contributed in their respective field. So let me take this subject ahead. What the intellectual property is all about. This is just like another asset. Like as I mentioned earlier, like there is a tangible and intangible. Like this is intellectual property is a kind of intangible asset. So this is just like a tangible asset. It can be bought, it can be sold, it can be mortgaged, it can be licensed, it can be exchanged as well. हमें पहले लगता था कि नहीं ये तो हमें इसका तो हमें एक्सक्लूसिव राइट हो नहीं सकता, इसलिए तो पहले हुआ करता था कि दिमाग एक आदमी का था, लोग पैसा कोई और कमाता था. But now because of this wonderful awareness, everybody is now well aware. अभी ऐसा हो नहीं रहा. Everybody is well aware and they know how to have the exclusive right of intellectual property as well. If the owner acquires legal right over the property, he becomes exclusive owner. And IPR can give the two different kind of rewards to the owner. One is legal right. Other is going to be possible rewards. So legal rights means nobody can, like once, let us say you have developed some product, right? So you will be exclusive owner of that. So legal right, if somebody is doing some sort of infringement, agar koi duplication kar raha hai, to you can go to the court of law and then you can sue him and you can penalize him as well through court of law. Moreover, the possible rewards could be in terms of money, in terms of honor in the society, and at the same time in terms of possible rewards as far as the national, as far as wealth is concerned. Now there are two different kinds of mainly intellectual properties: industrial properties and copyright. Industrial properties consisting of patent, designs, trademarks, and geographical indicators. I'm going to tell you some trade secrets as well, but I thought like let me give you the glimpses of the significant glimpses of these industrial properties. And similarly, as far as copyright is concerned, we have got the writings like books, research articles, musical work, dramatic works, पेंटिंग्स एंड ड्राइंग, साउंड रिकॉर्डिंग, ब्रॉडकास्ट. क्योंकि देखिए हमारे गांव की बात कर रहा हूं मैं, फॉरगेट अबाउट सिटीज. हमारे गांव में इतने अच्छे, बिकॉज नाउअडेज यू मस्ट हैव सीन, एक समय था, आप देखिए आई एम गोइंग टू कोट हियर टू एग्जांपल्स. एक समय था क्रिकेट में, लाइक वी यूज्ड टू हैव द पीपल प्लेयर्स फ्रॉम मेट्रोपॉलिटन सिटीज ओनली. We used to have the player from the well-established families only. But since last 1 decade, like when since Dhoni started playing, आपने देखा होगा कि छोटे-छोटे गांव से लोग बच्चे आ रहे हैं, and they are creating significant impact as far as cricket is concerned. Similarly, आप देखेंगे कि आजकल because of there are many live programs happening on the various television channels. As a result of that, आजकल हमें पता चल रहा है कि पहले तो हमें लता मंगेशकर पता थे, उनके सिस्टर पता थे. There were very Kishore Kumar and there were a very limited number of singers, you know, in this particular industry. लेकिन आप आज अगर देखेंगे तो there are many new people, new singers are coming, and they are not from well established families. They are not from like, you know, like metropolitan cities. They are from very small like rural areas. कोई ऐसा नहीं कि जो established family से आ रहे. The reason being they do have a talent, बट अनफॉर्चुनेटली पहले वो टैलेंट को पनपने के लिए मौका नहीं मिलता था. फॉर्चुनेटली नाउ देयर आर एन नंबर ऑफ प्लेटफॉर्म्स अवेलेबल. इसलिए हमें पता चला ड्रामेटिक्स आर्ट में वैसा ही, बिकॉज माय यूनिवर्सिटी हैज गॉट ड्रामेटिक डिपार्टमेंट एंड वी हैव सीन लाइक मेनी स्टूडेंट दे आर डूइंग एक्सेलेंट परफॉर्मेंस इन various stages, right? See, same thing is true with sound recording as well. So like this, like there are many area in which we can have the copyright as well. There are let me tell you the major types of IP, like functional and technical inventions. Like Patent Act, as I mentioned earlier, it came in 1970, and later on it has got 2 times amendment in 1999 and 2005. Similarly, Copyright Act, it was very long. आप देखिएगा 1957, ये नया नहीं है. पेटेंट भी 1970 से आया. हमें अभी अवेयरनेस हमारा हो नहीं रहा, हमें पता नहीं था. दैट इज द ओनली डिफरेंस. कॉपीराइट भी 1957 का है. उसके बाद कितने बार अमेंड हुआ? 1 2 3 4 5 टाइम्स अमेंडमेंट हुआ. ट्रेडमार्क्स का वैसा ही है. 1999, अब देखिए 21 साल पहले अमेंडेड इन 1994, 1996, 2000. इसका मतलब ये है कि यू कैन सी ऑल दोस टाइप्स ऑफ आईपीज लाइक काफी पहले से आए हैं, बट अनफॉर्चुनेटली हम लोग अवेयर नहीं थे. थोड़ा एग्जांपल मैं बताऊं डिजाइन का. आपको पता होगा कि कोल्हापुरी चप्पल तो आप जानते होंगे. कोल्हापुरी तो काफी ओल्ड हुआ, लेकिन अभी आप देखेंगे कि देयर आर मेनी ब्रांड, you know, like they are having a very specific designing on their own. अब जैसे कि एग्जांपल में बताऊं, ये चप्पल तो शायद आप पता नहीं होगी कि नंबर से पता नहीं चलेगा, बट आई कैन टेल यू, आई कैन कोट. दीज आर 2 एग्जांपल. बाटा का हश पपी का एक वेरी स्पेशल ब्रांड, यू नो, स्पेशल ब्रांड ऑफ बाटा, यू नो, लाइक हश पपी, which is a formal shoes. ये इस टाइप का डिजाइनिंग जो है आपको कहीं और नहीं मिलेगा. You are going to have a similar kind of design, लेकिन बिल्कुल exactly replica आपको कहीं पर भी नहीं मिलेंगी. And as a result of that, उसने काफी पैसा कमाया, अपना एक reputation कमाया. Similarly, Woodland का ये जो main shoe है, black leather shoes जो है, this is also very famous. Like that, there are many companies. Not only I have quoted 2 examples. There are many companies that they have come up with their own design and they earn money like anything. What kind of this design is applicable for any article, 2D or 3D, or in both form, applicable by any industrial process. Such design should not be contrary. Only thing is that it should not be contrary to public order or morality, or does not contain explicit or shameful matter. That is the only care that we have to take. As far as the duration is concerned, you can have, once you have the design, the copyright design right with you, you can have the exclusive right for 10 years, and it can be extended for another 5 years. And what are the benefits? Benefits are proprietor has exclusive right to apply the design. Commercial value, success, commodity is greatly decided by the external appearance and aesthetics. Because you see, आजकल बहुत सारे नए जनरेशन के बच्चे हैं कि उनको उसी टाइप का शूज चाहिए, उसी कंपनी का चाहिए. There are many. This is like some of the examples I have quoted. There are many brands nowadays. It's not only shoes, but as far as clothes is concerned, new generation people, they are very fond of those specific brands only. And as a result of that, they have, they benefited like anything. Similarly, trademark is another IP. This is basically visual symbol in the form of word, name, logo, label, etc. It is acceptable to any article of commerce. Help customer to distinguish and identify product of same kind and different make. Like for example, आप देखिए, आपको पता होगा computers, HP and Vivo. This is from manufacturing industry. This is just like 2 example I have quoted. There are many example of this kind. ये अगर हमें HP लेना है, आपको ये ट्रेडमार्क देख के आपको पता चल जाता है कि this belongs to HP. इसका डुप्लीकेशन कोई नहीं कर सकता. अगर मान लो डुप्लीकेशन करते समय पकड़ा गया तो he can be like penalized like anything. Similarly, this is for Vivo. Like this is some of the example I have quoted here. but there can be many examples. Like आप देखिए मैकडोनल्ड का, आप देखिए वेरी, किसी भी सिटी में जाइए, दूर दूर से आपको एम दिखाई देगा, तो आप यू कैन रीच देयर इफ यू आर फॉन्ड ऑफ मैकडोनल्ड फूड. कोका कोला है, विमल है. Similarly, as far as service industries is concerned, नॉर्थ एयरलाइन के काफी ऐसे ट्रेडमार्क है, जैसे कि नॉर्थ वेस्ट एयरलाइन, राइट. सिमिलरली द सर्टिफिकेशन मार्क्स है. अब हमें पता होगा कि एक समय था, अभी भी लाइक इफ यू वांट टू रियली ट्रस्ट, अभी भी देखिए ना, फॉरगेट अबाउट any standard, even nowadays also what corporation is doing, corporation जैसे कि मिड शॉप है, अलग अलग शॉप जो है, food shop particularly, the corporation always ensure that they are going to put their stamping. And whenever you are having stamping, it means that it reflects some sort of quality, right? So whenever the certification marks are there, it you will be like हमारे पास कुछ भी हो सकता है. That is why we always we are always doubtful in India, but in most of the developed countries, whenever some certification marks is there, you need not doubt. मतलब आपको बिल्कुल फिक्र करने की जरूरत नहीं है. As far as there are more examples of these service industries. As far as the duration is concerned, initially you can get this trademark exclusive right for 10 years. You can have another 10 years extension, and like this, you can keep on extending another 10 years till infinite time. What kind of benefits you can have with the trademark? Create a brand identity. आप देखिए, जैसे इंडियन एयरलाइन है, एयर इंडिया है, you know, British Airways hai. So you need not because whenever you are on the airport and if you see that that trademark, you will come to know that this belongs to that, right? Influence consumer positively. There is no negative influence. Products stand out in the market cluster. अगर आप कितनी भी बड़ी मार्केट है, but if you could show, देखिए HP का प्रोडक्ट देखिए, HP का ये देखिए, आप लैपटॉप देखिए, computers देखिए, because there are some people, the customers, they will exclusively prefer only HP. They can transcend language barrier as well. जैसे कि मान लो आपको लैंग्वेज का कोई बैरियर नहीं होगा, आप लेट से आप जापान चले गए, कोरिया चले गए, ताइवान चले गए, जहां पर इंग्लिश बहुत कम बोली जाती है, वहां पर भी आपको यू आर लीस्ट बॉदर्ड. आप ब्रांड देखते ही आपको बोलने की जरूरत नहीं है. You need not speak in any language, but still you can have that product and you can sell that product as well. Brand value increases with usage and time. Perpetual asset, this is always easy. It can be sold and it can be licensed, as I mentioned earlier. Provides protection against unfair competition using limitation. Like sometimes जैसे हम कहते हैं ना कि उल्लासनगर मेड, वैसे हम कहते कि is made in उल्लासनगर. So like that earlier it used to happen. लेकिन आजकल laws और rules इतने stringent हो गए कि if somebody is doing duplication, he can be like penalized in the court of law like anything. And therefore, if you are having trademark registration on your name, you are going to be benefited like anything. You need to take care of whenever you are registering trademark. आपको वैसे आपको करने की जरूरत नहीं, लेकिन प्रपोज करते समय आपको देखना पड़ेगा कि trademark should not belongs to any class or marks prohibited by law. जैसे कि फॉर एग्जांपल अशोक स्तंभा ये ऐसा है कि आप किसी भी ट्रेडमार्क में आप यूज नहीं कर सकते. So you need to see like what are the prohibited symbols that you have to take care of that whenever you are proposing. अगर आप प्रपोज भी करते हो तो आपको मिलेगा नहीं. TM should not contain any offensive matter or should not hurt religious feelings. जैसे कि मान लो किसी religion की feelings related to color or related to any particular word or sentence, that should not be there in the trademark. So we have to be very careful about that. Next is going to be geographical indicators. Now, what is the importance of geographical indicators? It identifies agriculture, natural and manufactured goods originating from definite territory. बहुत पहले ऐसा हुआ करता था कि जैसे कि आपको पता है कि नागपुर के संतरा, हमें पता है नागपुर की संतरा है, but still you know like the oranges are being grown across the country, but still Nagpur has its own speciality. नागपुर हैज इज ओन स्पेशलिटी. तो पहले क्या हुआ करता था कि अगर मान लो इट्स नॉट ओनली लाइक जनरेटिंग, इवन इफ यू आर प्रोड्यूसिंग, right, you can see in case of manufactured good, either the production or processing or preparation of the goods takes place in such a territory, region or locality. मतलब आपको तीन में से एक अगर क्लेम कर पाए कि either उसका मैन्युफैक्चरिंग या हो रहा है, या प्रोडक्शन या हो रहा है, या प्रिपरेशन या हो रहा है, या ग्रोथ या whatever, like if you could prove that, obviously you can have the geographical indicators by the name, and then nobody else will be able to do that. Nobody else will be able to do that. if you could do it, let me tell you, my friend, you can maintain the parity as well. जैसे कि मान लो अगर नागपुर में एक पर्टिकुलर कोई क्रॉप अगर ईल्ड ज्यादा है, it should not be duplicated across the country, right? नागपुर की स्पेशलिटी है ना, let them grow. औरंगाबाद की स्पेशलिटी है, let them do that business, let them grow those crops, right? So if you could do this, parity can be maintained and wealth वहीं के वहीं रहेगी. Unfortunately, ऐसा हो नहीं पाया पहले, but now this thing started happening. So these are some of the example like Darjeeling tea, Nagpur orange, Assam tea, Bidri work, Kolhapur jewelries and chapels. And most importantly, like if the females are attending, I'm sure there might be many females attending this workshop. For them also, Paithani sarees, like it is very special. You can have Paithani sarees across the country, but the original Paithani saree you can have only in Aurangabad and nearby region. Similarly, Banarasi silk, Lucknow chicken sarees, Madurai, there are many. I have quoted some of the examples. Like these are in fact like some of the examples of geographical indicators. Now, what are the benefits? Benefits is like if you can have registration on your name, then definitely legal protection can be you will be able to protect it. Two more example I can show you, because fortunately I've been to this place, Champagne. This is very famous sparkling wine of France. I've been to that industry as well, because Reims is the place where this champagne is being produced. I've been to that place, very famous. They could do it. Like Scotch is another. Those who are the wine lovers, for them this is a really wonderful slide for them. But let me tell you, my friend, unfortunately in India, basmati rice was supposed to be like unfortunately, like this is usually used to grow since years together in Indian territory. But unfortunately nowadays there are many foreign countries, because I was in US for quite good number of years. I have seen that like earlier people used to prefer only Indian basmati rice, but later on there are many Gulf countries, many European countries, forget about Gulf countries, many European countries, they started growing basmati rice. And there was a fight in the court between India and European countries, like, but somehow we lost the battle, unfortunately. Now I'm going to tell you, this was related to different properties. Let me tell you some information about copyright and related information, because this is going to be very important for the teachers who are working in the affiliated colleges. Copyright kya hai? What is copyright? The exclusive right given by the law for certain terms of years to an author, composer, or his assignee to print, publish, and sell the copies of his original work. So this is as per, there are different definition of copyright. This is as per Oxford English Dictionary. लेकिन क्या है, ये हमें क्या देता है? एक्सक्लूसिव राइट देता है. लेकिन हमारे पास जितने भी किताबें हैं, क्या हम उसको प्रिंट कर सकते हैं? नहीं कर सकते ऑफिशियली. Although I am the author of book, but I don't have that right. I cannot sell on my own, क्योंकि जिस पब्लिशर ने वो किताब पब्लिश की है, he has the copyright of my book and he is earning money, unfortunately. So we need to, इसलिए मेरी request है सभी teachers को कि whenever you are writing book, what we need to do is, truly speaking, right in the beginning, before you start writing, write the preface of your book, preface and content, elaborative content. आप उसकी क्या कहते हैं, अनुक्रमणिका मराठी मध्ये म्हणतो आपण. So if you write that content and illustrate like what kind of chapters is going to be, आप उस किताब में क्या chapters होने वाले, who will be beneficiaries of your book. आप देखिए कि you should anticipate like who are going to be beneficiaries of your book. मतलब आपकी किताब के beneficiaries कौन है, ये अगर पहले anticipate करेंगे आप, and if you could write that in the introduction section, preface section, in content section, and probably like what is going to be there in the book, and send it to different publisher. And let me tell you, my friend, if you do it like this, there will be huge number of queue in front of you. सभी लोग कहेंगे कि साहब हमारे साथ आप काम करो. But then you can dictate the terms. आप बोल सकते हैं कि nothing doing, copyright will be with me. I can give right to you just to sell maybe for 1 year or 2 years. Because this is how the importance need to be created. आप अगर इस टाइप का importance create करके किताब लिखना, हम अगर, आप नहीं, मैं कहता हम अगर करना शुरू करेंगे, तो I'm sure we are going to have a lot of copyright with us. Forget about only the copyright, but you will be able to earn a lot of money out of that as well. What are the copyright? What copyright protects? Like original, literally, dramatics, musical, artistic work, films, movies, sound recordings. And what is the term? Depends on the nature of the work, a owner of the copyright, and whether the work has been published. On an average, most of the copyright is lifetime is for the lifetime of the author plus 60 years. Like it is going to be for lifetime of the authors plus 60 years. And as far as broadcast, production, reproduction is concerned, it is going to be for 25 years. Now, what are the literary work like novels, poems, short stories? जैसे देखिए हमारे पास इतने सारे poets होते हैं कि they write poems like anything. There are many people in rural places कि चलते फिरते कविताएं वो लिख सकते हैं. But unfortunately, and they have some books as well. They have some books. Forget about teachers. I have seen like my father. He was 7th class, failed during those days. But he was having one book, one particular like collection of his own poems. But somehow, just because of lack of awareness, we could not publish it, and we cannot own his own copyright. And as a result of that, we could not earn the money as well. तो हमारे पास ऐसे काफी लोग होते हैं कि नॉवेल्स लिखते हैं, पोएम्स लिखते हैं, शॉर्ट स्टोरीज लिखते हैं. क्योंकि देखिए कि आजकल देखिए कि जो कॉलेजेस, इंटर कॉलेजेस जो कॉम्पिटिशन्स होती है, कल्चरल इंद्रधनुष इस टाइप के जो कॉम्पिटिशन होती है, वहां पर हम देखते हैं कि देयर आर मेनी पीपल, मेनी ग्रुप फ्रॉम द स्मॉल कॉलेजेस, they are coming up with wonderful, very nice stories, and they are playing the drama in the competition, that are being prizes as well. But somehow, if those stories has been drafted properly, if it can be copyrighted, it can be, it could be a wonderful source of wealth as well, right? Similarly, books on any subject. Books देखिए हमारे पास काफी books हैं. Research articles research article तो I can understand that whenever you are publishing research article, obviously the journal owner or journal publisher, or publisher rather, he is going to have the copyright. That is true. But as far as book is concerned, definitely we can have the copyright on our name. Then computer programs, computer databases. There are many students, even computer के बच्चे होते हैं कि they write their own algorithm. खुद का algorithm होता है, लेकिन फिर भी उसका copyright उनके पास होता नहीं. There are many students, they are creating their own databases. There are many students from rural areas, they are creating their own databases, but still they don't have copyright with them. Lyrics, तो song lyrics, तो there are many examples. कंप्यूटर सॉफ्टवेयर के मैनुअल्स है, पंच कार्ड्स है, मैग्नेटिक टेप है, कंप्यूटर प्रिंटआउट्स है, कंप्यूटर प्रोग्राम्स है. Now, sometimes patent don't always work. Why? The patent confer the monopolies and excludes competitors from conducting research. Because whenever sometimes whenever you are having patent, let us say you can have the patent, jurisdiction could be entire country. If the jurisdiction is the entire country, जिस एरिया में आपको पेटेंट मिला है, उस एरिया में आपने कंपटीशन को स्टॉप कर दिया. दूसरा कोई वो उस एरिया में काम ही नहीं कर सकता, उस पर्टिकुलर टॉपिक पे कोई काम ही नहीं कर सकता, बिकॉज यू हैव ऑलरेडी अर्न द प्रोडक्ट. सो एज ए रिजल्ट ऑफ दैट, इससे क्या होता है, कंपटीशन खत्म हो जाता है, राइट? एंड मोस्ट इंपॉर्टेंटली, जब व्हेनेवर वी आर टॉकिंग अबाउट पेटेंट, देयर इज नो गारंटी that is going to give you some financial benefits, because unless whatever patent you are going to file, whatever patent you are going to have, if it is not being commercially, if it not being financially viable, there is no use of those patent as well. But वो तो बात आगे की है. सबसे पहले तो मैं कहूंगा कि let us first of all let us have as many patent as you can on your name. सबसे पहले तो पेटेंट हमारे नाम पे हम शुरू करेंगे. बट मैं बताना चाहता हूँ कि पेटेंट को मतलब उसको मेंटेन करना भी मुश्किल है. एवरी ईयर यू हैव टू पे द फीस. if it is not commercially viable, it's going to be, you will be in loss. मतलब आप लॉस में रहेंगे. And despite of conferral of monopoly, usually another option available, जैसे मैंने बताया कि copyright could be a wonderful option. जहां पर कोई competition नहीं होता, जहां पर non obviousness, novelty का कोई सवाल create नहीं होगा. And as a result of that, there is lot of infringement too. क्योंकि infringement, क्योंकि यहाँ novelty नहीं चाहिए, इसलिए infringement काफी होता है. So infringement किस टाइप की होती है? Like copying, there are two different kinds of copying. एक जो है कैजुअल कनेक्शन हो सकता है, दैट आल्सो नॉट गोइंग टू बी कंसीडर्ड. सबकॉन्शियस कॉपिंग रही तो भी नहीं चलेगा, इनडायरेक्ट कॉपी रही तो भी नहीं चलेगा. व्हाट इज सब्सटेंशियल? सब्सटेंशियल इज गोइंग टू बी अनअल्टर्ड कॉपिंग. दिस इज वेरी वेरी डेंजरस. ऑफ कोर्स दिस इज नॉट डेंजरस, बट दिस इज गोइंग टू बी वेरी वेरी डेंजरस. अनअल्टर्ड कॉपिंग, अगर मान लो as it is paragraph nowadays, because this is what it is happening in case of research paper. आजकल काफी student, because now everything is available on tip of our finger, and as a result of that हम लोग क्या कर रहे हैं, हमारे बच्चे क्या कर रहे हैं, because if I want to write some research paper, I'm going to see like research मतलब website, अलग अलग website में browse करता हूँ, and then I would like to see like what is happening elsewhere, and then I will download those paper and try to copy paste it, right? If you do that unaltered copying, let me tell you, my friend, nowadays this plagiarism, there are many plagiarism softwares available online. Whenever you are submitting like copyright application, or whenever submitting a research article to any journal, the very first test that the editor is going to take is like plagiarism. Like whenever, like nowadays, like anything more than 10%, it is going to be written back. Like nobody is going to accept plagiarism more than 10% nowadays. So you have to be very careful. Even self plagiarism is also not acceptable. Like if you are copying some text from your own earlier work, which is already been published, that is not going to be considered even today, right? And therefore, this this factor of infringement is going to be very, very critical as far as the copyright is concerned. This is going to be the website through which you can get the copyright information, copyright.gov.in. All the details copyright information can be obtained. There are two types of rights you are going to get through copyright, like moral rights, which protect the personality of author, the economics right to bring the economic benefits. Now, what is the right of authorship or right of integrity? Like, for example, the digital manipulation can be done, right? I mean, for example, आपके पास एक digital copy है, उसके आप changes, उसमें आप जो चाहे वो changes कर सकते, because copyright आपके पास है. A right of display, like since you have the copyright with you, you can display anywhere. If you don't have copyright with you, you cannot display any book without permission of the person who is having copyright. Unfortunately, आजकल जो हो रहा है display का, that is illegal. वो legal नहीं है, because उनको कोई right नहीं दे दिया जाता है. Truly speaking, उसमें भी वो कोर्ट ऑफ लॉ में अगर कोई जाता है, मान लो मेरा कोई किताब है, कोई डिस्प्ले कर रहा है विदाउट माय परमिशन, I can penalize him in court of law. जो ये अवेयरनेस हमें नहीं है, but still मतलब डिस्प्ले कहीं पर भी विदाउट परमिशन आप डिस्प्ले नहीं कर सकते. As far as economics right is concerned, right of reproduction, making copies, for example, additional copy of novel, like you have got, to begin with, you have got 100 copies. You cannot, if you don't have copyright, you cannot make 1000. If you are having copyright, you can make as many copies as you can. You can provide short, like digital version also, storage on computer memory. You can have the digitized version of the book if you are having copyright form. If you don't have, you will not be able to have that. Right of distribution, ensuring copies, like digital distribution आप कर सकते हो. Like communication, like public performance, मान लो आपका खुद का किताब है, right? Then आप अगर उसके ऊपर कोई आपको कोई ड्रामा, एक छोटा ड्रामा अगर कहीं प्रेजेंट करना है, तो you can do it. But if the copyright is having somebody, if somebody else is having copyright, then you need to have his permission, without which you cannot do it. इंटरनेट कम्युनिकेशन, मान लो आप थ्रू इंटरनेट आप अगर उसको कम्युनिकेट करना चाहते हो, थ्रू डिजिटल मीडिया आप काफी लोगों को भेजना चाहते हो, दैट यू कैनॉट डू इट इफ यू डोंट हैव द लीगल राइट, इकोनॉमिक राइट. मोरओवर, लाइक कन्वर्जेशन इनटू अनदर फॉर्म, मान लो आपका इंग्लिश का किताब है, मराठी में आप कन्वर्ट कर सकते हो, मराठी का है इंग्लिश में कन्वर्ट कर सकते हो, आपके पास रहे तो. कंडेंसेशन कर सकते हो, मान लो आपको पता चल रहा है कि किताब बहुत बड़ा है, आई वांट टू कंडेंस इट. कॉपीराइट है तो आप कर सकते, नहीं तो नहीं कर सकते. आप पिक्चराइजेशन कर सकते हो, जो स्टोरी है, मान लो नॉवेल आपने लिखी है, यू वुड लाइक टू डू द पिक्चराइजेशन इन पिक्टोरियल फॉर्म, यू वुड लाइक टू पब्लिश इट, दैट आल्सो कैन बी डन. ट्रांसलेशन राइट, रेंटल राइट, आप किसी को रेंटल से दे सकते हो, रीसेल राइट आपके पास आ सकता है. एज फार एज द ओनरशिप इज कंसर्न, जैसे कि अब कोई पोएम है तो ऑथर इज गोइंग टू बी लिटरली वर्क, ऑथर इज गोइंग टू बी ओनर. ड्रामा है तो ड्रामेटिस्ट इज गोइंग टू बी ओनर. म्यूजिक है, कोई कंपोजर इज गोइंग टू बी ओनर. आर्टिस्टिक वर्क है, लाइक फॉर एग्जांपल पेंटिंग है, पेंटर इज गोइंग टू बी ओनर. फोटोग्राफ है, फोटोग्राफर इज गोइंग टू बी ओनर. कंप्यूटर प्रोग्राम है तो द पर्सन हु हैज क्रिएटेड दैट, ही इज गोइंग टू बी ओनर ऑफ दैट. मूवी या फिल्म है तो प्रोड्यूसर इज गोइंग टू बी, डायरेक्टर नो डायरेक्टर, बट प्रोड्यूसर इज गोइंग टू बी ओनर. साउंड रिकॉर्डिंग है तो अगेन लाइक प्रोड्यूसर इज गोइंग टू बी ओनर. एंड इन कोर्स ऑफ एम्प्लॉयमेंट, फॉर एग्जांपल आप कोई जॉब करते हो, राइट, जैसे फॉर एग्जाम्पल आप न्यूज़पेपर में जॉब करते हो एंड यू ड्राफ्टेड वन न्यूज, सो यू आर नॉट गोइंग टू बी ओनर ऑफ दैट बिकॉज सिंस यू आर, बिकॉज दिस इज योर, ये आपका जो ड्यूटी है, ड्यूटी एज ए पार्ट ऑफ योर ड्यूटी यू आर डूइंग दैट वर्क, सो यू आर नॉट गोइंग टू बी ओनर, the owner of that newspaper is going to be owner of that property. And photograph, painting, cinema of or valuable consideration, अगर जो पे करता है he is going to own. That is why you must have seen the Mona Lisa. उनकी जो पेंटिंग है लाखों करोड़ों रुपए में बहुत बार बेची जाती है, because whenever you are buying that, you are going to have the exclusive right of that particular property. Similarly, आप लेक्चर डिलीवर कर रहे हो, जैसे कि फॉर एग्जांपल आई एम डिलीवरिंग टॉक, so I'm going to be owner of whatever the IP I'm generating. I will be owner. Nobody else can be owner of this particular IP. गवर्नमेंट में, आप किसी गवर्नमेंट में जॉब करते हो, वहां पर एज ए पार्ट ऑफ योर ड्यूटी इफ यू आर डूइंग, लेट अस से you are working in a census office and you have developed some like some data, right, some manual, right, so you can never be owner of that manual because you have developed that as a part of your duty, so you can never be owner of that. Similarly, if you are working in public undertaking like universities, for example, if I work in university and like जो class में मैं पढ़ा रहा हूँ, so whatever teaching I am doing as in the class, so I can never be owner of that because that is a part of my duty. But whatever books I am writing, because books is my own creativity, so that is going to be, I'm going to be owner of that property. So like that, this will go. Now, as far as the securing copyright is concerned, if you go through the Copyright Act, serial number 44 and 45, you will get the all kind of details about the registration. As far as fees is concerned, there are different categories of copyright filling, but I would say you can see 9 number. For an application for registration of copyright, literally dramatic, musical, artistic work, you have to pay only 500 rupees, not more than 500 rupees. So there are different options available for fees as well. Quickly, let me, maybe within 5-10 minutes, I will finish and then I will stop. Patents and related like. So as far as patent is concerned, as I mentioned earlier, a patent is an exclusive right granted by the government to the applicant who discloses his or her or their invention. Right? Invention can be product or process. जैसे मैंने बताया कि invention can be either product or it can be process. But provided it should have these 3 properties. It should be new, that is novel. It should be non-obvious, and it should have industrial applicability. This is very, very important. I'm going to tell you how to test the novelty. Test of novelty, non-obviousness, and industrial applicability. Usually, whenever you are having patent, it is going to be valid for 20 years. And again, this is a territorial right in the country where it is granted. Let us say, for example, मैं India में करता हूँ, तो I am going to have the exclusive right across the country as far as India is concerned. Okay, so there are different options available. What kind of protection you are going to have? No patented invention can be commercially made, used, distributed or sold without patent owner. जैसे मैंने बताया कि once it is patented, 20 साल के लिए you are going to be owner, right? So nobody can commercially use it, distribute it, sell it. Nobody can do it. If somebody is doing that, obviously you can penalize him in the court of law. Conversely, the court can also declare patent invalid upon the successful challenge by the third party. जैसे कि मान लो आपको एक बार पेटेंट मिला है, इसका मतलब ऐसा नहीं कि आप बेफिक्र हो गए. No, like for example, whenever I got the patent granted, it is going to be in public domain. So जब public domain में आता है तो anybody can challenge. So anybody can go to the court of law and they can challenge. If he gets successful, मेरा पेटेंट जो है मुझे विड्रॉ भी करना, गवर्नमेंट विड्रॉ भी करती मेरी, right? So that is why this is very, very important. Like third party challenge always threat रहेगा. So whenever you are submitting a patent, it should be full proof. It should be वो 3 टेस्ट जो है वो टेस्ट अगर सही रहे, so then nobody can challenge your patent. Owner has right to decide who or may not use the patented invention for the period during which it is protected. जितने भी साल आपको मिले हैं वो आप पूरे exclusive right आपके पास रहेंगे. As far as the jurisdiction is concerned, every country has their own IP management system. Like World Intellectual Property Organization is the global forum for intellectual property services. उसका headquarter जेनेवा में है. इसके कुछ इंपॉर्टेंट माइलस्टोन है. सबसे पहले आर्टिकल यूनिवर्सल डिक्लेरेशन, ह्यूमन राइट की यूनिवर्सल डिक्लेरेशन हुआ था राइट इन द बिगिनिंग. उसका 27 आर्टिकल में आईपी का सबसे पहले जिक्र किया गया था। लेटर ऑन लाइक दिस वर्ल्ड, ये जो है ना वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन, वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन WIPO, राइट, इन लोगों ने सबसे पहले इंटरनेशनल समिट ऑर्गेनाइज किया था पेरिस में 1883 में, सेकंड वाज इन बर्न 1886, and since then there has been substantial revolution in this particular IP Act, and accordingly every country has adopted that. What Intellectual Property Day people started or celebrating since long, it is on April 26th. As far as Indian scenario is concerned, this is the website of India, www.ipindia.nic.in. यहाँ पर आपको सब इंफॉर्मेशन मिल सकती है. There are 4 territorial offices: Mumbai Patent Office, Delhi, Chennai, and Kolkata. Gujarat and Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, they comes into the Mumbai Patent Office. And apart from the registration, this institute, the Rajiv Gandhi National Institute for Intellectual Property Management, is apart from providing other services, right? This is the only center across the country where the training is being provided. And I was fortunate to have 1 week training in this particular Rajiv Gandhi National Institute for Intellectual Property Management 4-5 years back. There are some international treaties as well. Like if you really want to get yourself aware, I would advise you to see those treaties as well, so that you will get aware about these international treaties. And then some you need to know some IP laws as well. Quickly you can go through that. Very important: Copyright Act 1957 क्या है, Patent Act 1970 का क्या है, Design Act 2000 का. Obviously इसमें मैंने बताया, जैसे पहले बताया, इसमें अमेंडमेंट भी आ चुके हैं. आपको अमेंडमेंट क्या है वो भी पता होना जरूरी है. ट्रेडमार्क्स एक्ट 1999 का क्या है, जोग्राफिकल इंटीग्रेशन का जो है 1999 का क्या है. सिमिलरली सेमीकंडक्टर इंटीग्रेटेड सर्किट, जो दोज आर फ्रॉम इलेक्ट्रॉनिक्स इंफॉर्मेशन टेक्नोलॉजीज, जो आईसी का जो लेआउट होता है उसका भी हम कॉपीराइट ले सकते हैं, उसका एक्ट क्या है. एंड देन प्लांट वैरायटीज एंड फार्मर्स राइट एक्ट, क्योंकि अगर मान लो एग्रीकल्चर में आप अगर कोई प्लांट, नया प्लांट अगर वो ग्रो कर रहे हो, अकॉर्डिंगली थ्रू दिस एक्ट यू कैन रजिस्टर दैट ऑन योर नेम एंड नोबडी कैन डुप्लीकेट इट. सो इसमें कुछ अमेंडमेंट भी आए हैं. तो इसका मतलब ऐसा नहीं कि आप सब कुछ आपको पता होना चाहिए, बट इफ यू रियली वांट टू गेट योरसेल्फ aware or educated, I would advise you to at least have the preliminary fundamental knowledge of these laws, so that nobody can cheat you. As far as the patent is concerned, as I mentioned earlier, patent is an exclusive right granted by the government to the applicant and his or their assignee for their disclosed invention or of industrial process or product, which should be new, non-obvious and useful. जैसे मैंने बताया कि सबसे पहले क्या होना चाहिए कि एक पेटेंट इंडिविजुअल कि his, her, their इतना क्यों किया, क्योंकि उसका रीजन है कि आप इंडिविजुअल पेटेंट ले सकते हो, आप एक ग्रुप है वो पेटेंट ले सकते हो, आप किसी को असाइन कर सकते हो, राइट, और आप उसके नाम पे पेटेंट होगा क्योंकि आपने असाइन किया है. लेकिन पेटेंट किस बात पे मिलेगा, प्रोसेस पे या प्रोडक्ट पे, और क्या टेस्ट होनी चाहिए, न्यू, नॉन ऑब्वियस एंड यूजफुलनेस. Let me tell you some more information about the patent. Patent right is granted, as I mentioned earlier, for 20 years, limited period के लिए होता है. It gives territorial right and can be enforced only in the country where it has been granted. मतलब मान लो इंडिया में अगर मुझे मिला है तो वो मुझे इंडिया में ही चला सकता हूँ, क्योंकि डुप्लीकेशन ऑस्ट्रेलिया में हो सकता है, यूएस में हो सकता है. इसलिए अगर आप डुप्लीकेशन फार्मास्यूटिकल में यूजुअली होता है कि अगर इफ यू डोंट वांट एनीबॉडी to duplicate your invention, then what you can do, you can go for international treaties, right, PCTs. मैं आपको बताऊंगा PCT क्या है, so that you can ensure you can have the exclusive right not only for one country, but it may be for more than one countries. The patent right enables the inventor to derive material benefits as a compensation to his intellectual efforts. मतलब जो भी आपके intellectual efforts थे उससे आपको पैसा मिल सकता है. The important thing is right is protected for term of the patent provided that the renewal fees is paid as prescribed. जैसे मैंने बताया कि आपको every year अगर renewal fees अगर आप पे नहीं करोगे तो you will not be able to have patent on your name. आप अगर फीस नहीं पे करेंगे तो आपका पेटेंट विड्रॉ किया जाएगा. इसलिए आपका अगर कमर्शियल वायबिलिटी नहीं है तो what will happen, it will be very difficult for you to maintain the patent, क्योंकि आपको खाली पैसा गंवाना पड़ेगा, पैसा मिलेगा तो कुछ नहीं. Moreover, patentee should be his, her or their own policeman. जैसा कि मान लो आपके पास कोई पेटेंट है, आपने मान लिया कि अभी कोई डुप्लीकेशन करेगा नहीं, तो मान लो अगर मेरे पास पेटेंट है और मेरे कोई कलीग ने उसका डुप्लीकेशन किया है, तो पेटेंट ऑफिस आके उसको पेनलाइज नहीं करेगा. ये तो आपकी जिम्मेदारी, आपको देखना पड़ेगा. मान लो अगर आपको पता है कि कोई आपका डुप्लीकेशन कर रहा है आपके पेटेंट का, तो यू हैव टू गो टू द कोर्ट ऑफ लॉ, देन ओनली यू आर गोइंग टू गेट द जस्टिस. घर बैठे हुए कुछ नहीं मिलेगा. इसीलिए यहाँ लिखा है कि पेटेंटी शुड बी हिज, हर और देयर ओन पुलिसमैन. मतलब खुद देखना पड़ेगा आपको, ऐसा नहीं कि आप पेटेंट मिल गया आप शांत हो गए. नो. नाउ let me quickly tell you the three criteria. Novelty criteria क्या है? Novelty means new, in other words not known to the public in any manner. Novelty has to be assessed with respect to the priority date of first disclosure. And therefore my friend, whenever you are having ideas, जैसे कि जब हम पेपर रिसर्च पेपर जब पब्लिश करते हैं, वहां पर भी नॉवेल्टी एक क्राइटेरिया इंपॉर्टेंट है. बट वहां पर कैसा है कि लिमिटेड दायरे में उसको देखा जाएगा. सर्च जो है, क्योंकि आजकल देयर आर मेनी गुड, दैट इज द रीजन व्हाई यू शुड पब्लिश योर पेपर इन गुड जर्नल ओनली. आप अगर अच्छे जर्नल में पेपर पब्लिश करेंगे तो वहां पर नॉवेल्टी जो है बड़े मेटिकुलसली देखी जाएगी. दे आर गोइंग टू सी लाइक वेदर यू आर गोइंग टू हैव नॉवेल्टी वर्ल्ड वाइड. लेकिन अगर कोई सबस्टैंडर्ड जर्नल है तो क्या करेगा वो, बिकॉज उनका दायरा बड़ा नहीं है, उनका सर्च उतना तगड़ा नहीं है. एज ए रिजल्ट ऑफ दैट दे विल बी सर्चिंग योर नॉवेल्टी विद इन द वेरी लिमिटेड दायरे में वो चेक करेंगे. एंड एज ए रिजल्ट ऑफ दैट योर पेपर मे बी एक्सेप्टेड. बट से इफ यू सबमिट सेम पेपर टू द गुड जर्नल ऑफ इंटरनेशनल रेप्यूट, योर पेपर मे बी रिजेक्टेड जस्ट बिकॉज ऑफ नॉवेल्टी इशू. सो नॉवेल्टी क्या है? सबसे पहले मैं आपको बताना चाहूँ कि देयर शुड बी न्यूनेस. अगर मान लो, अगर इफ यू वांट टू एंश्योर दैट योर प्रोडक्ट शुड बी नॉवेल, देन इन एंटिसिपेशन ऑफ नॉवेल्टी यू कैन डू दिस. प्रायर पब्लिकेशन आपको देखना पड़ेगा कि जो वर्क आपने किया है उसका प्रायर पब्लिकेशन नहीं होना चाहिए, प्रायर पब्लिक नॉलेज नहीं होना चाहिए, प्रायर पब्लिक यूज नहीं होना चाहिए, प्रायर पब्लिक डिस्प्ले नहीं होना चाहिए, और किसी ने क्लेम नहीं करना चाहिए. अगर एक किसी में अगर वो दिखाया गया, मान लो आपने कोई डिवाइस या प्रोसेस आप प्रपोज करते हो, तो दिस इज गोइंग टू बी लाइक पेटेंट ऑफिस गोइंग टू मेक इट ओपन दैट दिस XYZ फेलो हैज सबमिटेड पेटेंट. डज एनीबडी हैज एनी ऑब्जेक्शन? तो यू कैन गो अहेड एंड रेज ऑब्जेक्शन कि ये तो मैंने पहले ही किया है. इसका मतलब क्या, वो पब्लिक को पता था, राइट? आप जाकर बता सकते कि दिस वाज ऑलरेडी पब्लिश हियर, इसका मतलब वो पब्लिकेशन हुआ है. आप जाके बता सकते कि ये तो इसने XYZ ने यूज करना शुरू किया है, इसका मतलब क्या हो, वो यूज कर रहे हैं. या तो आप क्लेम कर सकते हो कि ये मेरा प्रोडक्ट है, राइट? सो व्हेनेवर द नॉवेल्टी इज टू बी टेस्टेड, तो पेटेंट ऑफिस देखेगा कि वो उससे पहले कहीं पब्लिश तो नहीं हुआ ना, पब्लिक नॉलेज में तो नहीं ना, किसी ने यूज तो नहीं किया ना, किसी ने डिस्प्ले तो नहीं किया ना, और किसी का क्लेम तो ना है ना. सो अनलेस because this is going to be very horrible. And moreover, the patent office is going to do its own search. Apart from this, like, it's going to be in public domain, and they are going to have their own search as well. And therefore, novelty is going to be very critical. But let me tell you, my friend, discovery may pass novelty test, but it may not be patentable. जैसे मैंने बताया कि आप novelty अगर पास भी होती है तो भी non obvious ने टेस्ट पास होनी चाहिए. Second is non obvious, whether it is fine, it is like novel है, but non obvious है. जैसे कि मैं एग्जांपल देता हूँ, कि गुलाब जामुन, हमें पता है कि गुलाब जामुन मीठे होते हैं, राइट? वी नो गुलाब जामुन इज वेरी स्वीट. अगर मान लो मैंने गुलाब जामुन में हरी मिर्च डाल दी या तो रेड मिर्च डाल दी, तो इज गोइंग टू बी डिफरेंट, टेस्ट इज गोइंग टू बी डिफरेंट. सो डू यू थिंक दैट दिस इज गोइंग टू बी न्यू? अगर मान लो आपने गुलाब जामुन में कोई तीखा लाल रेड मिर्च अगर आपने डाल दी और कहने लगे कि दिस इज न्यू प्रोडक्ट, डू यू थिंक दैट इज गोइंग टू बी न्यू? नो, इज नॉट गोइंग टू बी न्यू. द रीजन इज, वहां पर नॉवेल्टी तो दिख रही है आपको, क्योंकि आप क्लेम कर सकते नॉवेल्टी, क्योंकि गुलाब जामुन मीठे होते हैं, ये तीखा है, राइट? सो नॉवेल्टीज है. बट वेदर इट इज नॉन ऑब्वियस, क्योंकि नॉन ऑब्वियस नहीं होगा. ये आप सेकंड देखिए, इन्वेंटिव स्टेप शुड बी डिफाइंड एज नॉन ऑब्वियस बाय द पर्सन हु इज स्किल्ड इन द आर्ट. जब आपका पेटेंट की एग्जामिनेशन होगी तो वहां पर जिस एरिया में आप पेटेंट सबमिट कर रहे हो उस एरिया के एक्सपर्टाइज वुड बी कॉल्ड देयर. You will have to show your experiment in front of expertise, those who are having expertise, right? तो आप देखिए कि मैं मान लो इस एरिया में गुलाब जामुन, मतलब इसमें मैं सेफ हूँ, बड़ा सीनियर सेफ हूँ, बड़े होटल में काम करता हूँ, इंटरनेशनल लेवल का सेफ हूँ, आई हैव गॉट मेनी डिग्रीज टू माई क्रेडिट। और कोई बंदा आके मुझे बता रहा है कि भैया मैंने मेरे गुलाब जामुन में तीखा डालकर उसकी टेस्ट चेंज कर दी, इज गोइंग टू बी नॉन ऑब्वियस? नो, he will say that this is quite obvious. If you change the ingredient, taste is going to be changed. So it is not non-obvious, it is obvious. So the test of non-obviousness should be there, and therefore, my friend, even if it is novel, it should be non-obvious, and therefore we have to be very careful about the data, I mean the claim which we are going to make. Then next is going to be as far as non-obviousness is concerned, scope and content of prior art, assessing the technical result or economical value, differences between the relevant prior art and claim. All these points are going to be taken care by the patent office whenever you are submitting patent and whenever it is going to be tested for non-obviousness. And third is industrial applicability. Industrial applicability means, fine, your test is novelty is naya hai, non-obvious hai, but whether it is going to be useful for the society. This is what you call as industrial applicability. If it is not useful for the society, somehow if you could not convince that patent office that this invention is going to be useful for this cross section of society, if you are failed to do that, your patent is not going to be granted. So my friend, there are three tests, very important tests: novelty, non-obviousness, and the industrial applicability. Unless you have the three tests, your patent is not going to be granted. And as far as the others, because I think I need to stop here because I should not go beyond this. I can quote some examples like the inventions which are not patentable. Like for example, आपको पता होगा अभी recently hydroxychloroquine tablet जो है, because we know that this tablet is being used to treat malaria. But nowadays, because malaria which is caused by mosquito, but nowadays we know very recently, आपको पता होगा कि जब ये पेंडेमिक आया तो even US started using this hydrochloroquine, and there are many patients they got cured also, right? Does it mean that this can be this concept can be patentable, that this is the new concept which can be earlier it was not used to treat COVID, but now we can treat this for COVID, and so that it can be patented? No, because we know this is not obvious at all, right? And therefore there are many medicine nowadays, because although we are waiting for vaccines have already came up, and we are going to have vaccination very soon, but abhi bhi hamara matlab there are very few patients there I mean कम लोग जो है unfortunate part है जो मतलब हम उनको बचा नहीं पा रहे, but there are many people they are surviving themselves, right? There are different alternative medicines, but can we patent those? Can we have the patent against, like मान लो ये XYZ medicine है, उससे अगर कोविड हम क्योर करें तो does it mean that we can patent, we can have patent of that? No, absolutely not. Similarly, there are there are many examples. Like for example, आप अगर एक well known example मैं बोलता हूँ आपको, and then I will stop. जैसे कि एग्रीकल्चर में हमें पता है कि एग्रीकल्चर में we always provide some sort of fertilizer, right? Fertilizer देकर हम we can enhance the yield of various crops. Does it mean that is going to be patented? No, because that is quite obvious. That is quite obvious. Like whenever you are giving fertilizer, whenever you are feeding fertilizer to any crop, you are going to have improvement, right? So you are going to have improved soil. Soil is going to improve because of fertilizer. This is obvious, right? And therefore that cannot be patented. That kind of idea cannot be patented. Okay. So, and moreover, any literally dramatic art, presentation, topography, all this can be copyrighted, but cannot be patented. This is the details of the fees which is needed for filing the patent, and the remaining part was like how to draft the patent, but time is already over, and moreover another speaker, Professor Bedkar sir, he is going to take care of patent drafting. In fact, otherwise I wanted to tell you what is filing patent, like what is the provisional specification, complete specification, what are the different options available, why should we file the patent, like what are the PCT, what is the Patent Corporation Treaty, right? And then as far as specification is concerned, as I mentioned earlier, provisional and complete. What what actually the patent specification means, right? And what actually the drafting means. What are the care that need to be taken while drafting patent? And then what is basically how to what kind of the confirmative test we have to take. What is the available information in the public domain, how to test it, and then what is the format of what is the format of filing the patent, what are different forms, right? And then as far as provisional specification is concerned, what is the format that we have to follow, and then I was supposed to give some example as well, and so on and so forth. But as I mentioned earlier, it's not going to be possible, and because it will take another maybe around 30-40 minutes, and anyway another speaker is going to take care of that. And therefore at the end, let me summarize. Intellectual property right provides the exclusive right to the inventors, provides legal defense and offers them incentives to their work, helps in social and financial development as well. सबसे important क्या है कि हमें legal right तो मिलते हैं, financial benefits तो होता है, and it helps us to improve our societal impact as well. And most importantly, the honest, committed, and focused efforts are required. Like if you really want to draft your patent on your own, let me tell you, my friend, if you really, because as far as the provisional specification is concerned, you can draft it. But again, like whatever, because truly speaking, provisional specification doesn't have any claim. So provisional specification can be drafted very easily. But if you want to file a complete specification, then you have to be very careful. I would advise you, if you are drafting first provisional patent, you can do it. But whenever you are submitting, because after provisional patent, there will be the gap of 1 year. I mean, you are going to get the leisure time of 1 year. And within 1 year, you can submit the complete specification. But लेकिन जब आप complete specification submit करेंगे, तब लेकिन आप अगर complete equipped नहीं हो, I will not advise you to do on your own. It will be better to take the help of patent attorney, because their claims are going to be very important. क्योंकि अगर claim में आप, क्योंकि वहां पर एक claim नहीं होगा, आपके invention के कम से कम 5-6 claims हो सकते हैं. क्योंकि बहुत बार अगर आप एक क्लेम जाकर बैठेंगे तो लोग जो है उसका अलग फॉर्म लेकर आपके आगे निकल जा सकते हैं. इसलिए because those who are patent attorney, they are well aware of all those technicality, because whenever we are talking about the draft of the patent, it is not only the technical, this is the techno legal document. इसमें खाली टेक्निकल इंपॉर्टेंट नहीं है, टेक्निकल नॉलेज इंपॉर्टेंट नहीं है, लीगल नॉलेज बड़ा इंपॉर्टेंट है. अगर आपके पास लीगल नॉलेज नहीं तो इट वुड बी वेरी डिफिकल्ट फॉर यू टू draft. So my suggestion would be provisional specification. Through this kind of workshop and hands-on, you can draft provisional specification, you can save money. But as far as complete specification is concerned, I would advise you to take the help of a patent attorney to file your complete specification. With this, I'm going to stop here, and now I would request the organizer to take the questions if at all there. Hello.
Deshmukh madam.
Have question? Anyone have any question? Okay, sir. Thank you, sir, for your deep insight and illustration on the intellectual property rights. Thank you. Really, your session was full of informative, innovative, as well as the enthusiastic. Really, sir, in the next future also, we'd like to listen to you. Thank you, sir. Thank you very much once again.
No questions?
No questions. I think no one is raising hands.
Okay. I would love to have questions.
Sir, yes, sir.
Yes, sir. Yes. We should have at least few questions, truly speaking. Yes. Otherwise, it's meaningless.
Actually, this is not a question, sir. Just query. Sir, will you shed light on the IPR and the fundamental rights? If there are any conflict between the two, intellectual property rights and the fundamental rights.
You see, there is a little bit conflict. Fundamental right is like whenever you said IPR, let us say, for example, I have got one patent of one particular product, right? So that cannot be duplicated by anybody, right? that cannot be duplicated. To some extent, there will be conflict on fundamental right, to some extent, right? To some extent, not a greater extent, but to some extent. But since I am having patent, nobody can claim, right? Somebody may say that this is my fundamental right, but I'm having patent on that, right? So that is why patent always like it minimizes the competitions. It kills the competition rather, because if it is open, let's say for example, I have developed one. Let us say I have developed one this bottle by one particular technology, right? If I don't have patent, it's open for everybody. Anybody can research, like they can come up with altogether different materials, and that could be more cost effective, and that could be like more useful as well, right? But if I'm having patent, then like it kills the competitions, right? And therefore, to some extent, there would be little bit of conflict, not on all aspects, but to some extent, it would be conflict with fundamental right as well.
Suppose a new medicine comes in the market, which cures the cancer.
Which gives the
which cures the cancer. Suppose a company, X company, has got the patent of that medicine, and that medicine is too expensive, where a common man can't purchase it. Okay.
Yes.
Now it is the fundamental right of a man to live.
Yes.
Okay. But he can't purchase that one. Now, in this case, the conflict arises.
Yeah,
how the government or the law protects the right and the IPR.
Yes, that is why the problem is like it again depends on jurisdiction. That is why the pharmacy company, they are very smart. They are having the entire globe as a jurisdiction, so that nobody can copy it. Otherwise, like if it is expensive, let us say for example, one vaccine costing, let us say 1 lakh rupees. In India, there are n number of people, they will not be that the 1 lakh rupees would not be affordable for them. Let us say another company in India providing similar kind of vaccine for the same disease, let us say for 10,000, they will not be able to do it if they are having India as a jurisdiction. And therefore, what happens, right? Therefore, like whenever you are granting patent, our patent office need to take care of this kind of aspect. It is happening like whenever it is going to have the conflict of this kind, many times that patent is not going to be granted, many times. But if it is granted, then you cannot do anything. If it is granted, then you cannot do anything.
Okay.
Sir, I have one question regarding copyright.
Yes, sir. Yes.
Sir, suppose one of the author has published book with copyright on his name.
Okay.
And if suppose publisher has published this book with another name or with another publication, but content is same,
then you can penalize him in court of law, like anything.
Where we have to complain? And
any court of law you can go. You can show that you can show because you see. First of all, you need to complain in the copyright office, right? Okay. That this fellow has do some sort of violation of rules, and then they will advise you what to do next step. First of all, you have to submit your complaint to the copyright office only. First of all, to begin with,
sir,
and then they will advise you what to do next.
Okay, sir. Where these copyright offices are located, sir?
Delhi. As far as copyright is concerned, we don't have jurisdiction, because even for Aurangabad also you have to go to Delhi.
Okay, sir. Thank you.
Okay, anybody has question? No, sir. Thank you, sir. Thank you for your deep insight and illustration on the intellectual property rights. Really, your session was very much informative and enthusiastic session. Thank you, sir. Thank you once again. Now, I would like to invite Principal Dr. V.D. Satpute, sir. He is from late Ramesh Varpudkar College, Sonpet, for his presidential address. Please over to you, sir.
Okay, thank you, ma'am. Very good afternoon to one and all. Sabhi ko namaskar, pranam. Being one of the hosts of this event, I welcome you all in this one-day national level virtual workshop on this intellectual property rights. which is being jointly organized by the IQCs of the three colleges, that is SPPM College Sirsala, LRWC College Sonpet, and Vasundhara College Ghatnandur. Honorable patrons or the motivating force behind this event, Honorable Venkatrauji Kadam Sahib, Honorable Parmeshwarauji Kadam Sahib, and Honorable Govindrauji Deshmukh. The very towering personalities we have got for this session as a resource person, that is Dr. M.D. Sirsat sir, Director USA. Then we have another resource person, that is Dr. M.M. Bedkar sir, Principal, Kumaraswamy College, Ausa. The principals of these colleges, Dr. H.P. Kadam, Dr. Dalvi sir, the IQAC coordinators, Professor Dhanve, Dr. Patil sir, and Dr. Alka Deshmukh ma'am, professors and the members from all the three colleges, and IQAC members and participants participating in this event from other colleges. At the very outset, let me express my gratitude to both the resource persons, that is Dr. M.D. Sirsat sir and Principal M.M. Bedkar sir, for accepting our invitation to talk on this theme. This national level workshop on this IPR, intellectual property rights, is very crucial in the today's context. The various workshops and the webinars or seminars are being organized on this theme since last 4 to 5 years. The UGC and NAC is also insisting to the various institutions to organize the awareness workshops and seminars on the topic. And the very reason behind this is that the IPR has been very important from the viewpoint of the industrial and economic development of the country. The protection of the intellectual property rights has become very essential in the changing global context. Thank you, Dr. Sirsat sir, for introducing this subject in a very lucid way. You made us conscious and very attentive about this intellectual property rights. This has been a very enlightening session, sir. Till date, we have just heard the names of the terms like IPR, patent, trademarks, GI, that is geographical indication, and copyrights or the industrial design. But your thorough dealing with these terms helped us to concretize the terms and remove the confusion in our mind. Particularly the teachers belonging to the humanities or the social sciences are very much unconscious of such type of terms. Sir, your enlightening keynote address will compel us to introduce the topic in classrooms, which will in turn inspire the new talent. Innovative ideas are at college level, no doubt. You have told us that even the teachers and the students possess this one, but the lack of awareness, that is we don't register it in a very proper way, that copyrights are not with authors. Sir, let me tell you that in my staff, number of books have been published by my faculty members, but I am little bit doubtful that how much among them have the copyrights. And now this onwards, I will check from tomorrow onwards and inspire my faculty along with the publication. Let there should be a copyrights with you, so that at least not for the NAC and UGC purpose, at least for the NIR purpose, we will use that one. I am very happy to know that we can have the such type of copyrights at the college level. You dealt with in a very detailed manner as far as the tangible and the intangible properties, that is the intellectual property, sir. And we have very innovative ideas, but we are unaware of it and we are unable to cache it. And therefore, this awareness has become very essential as far as the students are just concerned. Students must know about this IPR, because IPR helps innovators to protect their invention and provides better funding opportunities. In order to encourage the creative intellectual endeavor in the economy, this government has been making attempts at improving the IP culture in India by building an awareness on IPR. Sir, you just recently mentioned that even the government has recently proposed a reduce in the fees for the various IPRs like patents and designs for small business or the startups. It is near about 1600 per patent, and for copyright you just mentioned that only within 500 rupees you can register for the copyright, sir. As far as Dr. Bedkar sir is just concerned, he will deal on this aspect of the theme, sir. And in such a way, you have shown us the number of advantages as far as this IPR has got. It provides the exclusive, no doubt, rights to the creator, and it encourages the individuals to distribute and share information and data instead of keeping it confidential. And also it provides legal defense and offers the creators the incentive of their work. Thank you very much once again, sir, for your very enlightening talk as far as your keynote address is just concerned. Thank you very much. Over to Deshmukh ma'am.
Thank you, sir. Thank you for your presidential address for this first session. Now I would like to request Dr. Gajanan Somne sir from Vasundhara College to extend deep gratitude and vote of thanks for this first session. Please, Dr. Gajanan Somne sir, over to you.
नमस्कार। मैं प्रथमतः इस कार्यशाला अपना महत्वपूर्ण समय देकर तथा आशीर्वाद दिया है वह हमारे मार्गदर्शक आदरणीय माननीय वेंकटराव जी कदम साहेब, माननीय आदरणीय श्री गोविंदराव जी देशमुख साहेब और माननीय आदरणीय श्री परमेश्वर जी कदम साहेब, इनका आशीर्वाद रहा है। मैं इनका प्रथमतः आभार व्यक्त करता हूँ। इस कार्य के प्रमुख अतिथि डॉक्टर बाबा साहब आम्बेडकर मराठवाड़ा विश्वविद्यालय औरंगाबाद रूसा के संचालक आदरणीय महेंद्र शेषाक सर, इन्होंने बहुत ही आसान और सिंपल भाषा में अपना मंतव्य रखा है। इनका भी मैं आयोजक समिति के ओर से आभार व्यक्त करता हूं। इसके साथ इस कार्यशाला को प्रमुख अतिथि के रूप में उपस्थित रहने वाले प्रधानाचार्य व्यक्तिगत सर, इनका भी आभार व्यक्त करता हूं। इस सत्र के प्रमुख अध्यक्ष महाविद्यालय के प्रधानाचार्य डॉक्टर VD प्रसाद पुटे सर, इनका भी मैं आभार व्यक्त करता हूं। इस कार्यशाला को उपस्थित सिरसा महाविद्यालय के प्रधानाचार्य डॉक्टर हरिभाऊ कदम जी और हमारे महाविद्यालय के कप्तान प्रधानाचार्य श्री डॉक्टर अरुण दलवी सर जी, इनका भी मैं आभार व्यक्त करता हूं। इस कार्य सत्र के सुंदर सूत्र संचलन करने वाले हमारे सहपाठी डॉक्टर अलका देशमुख जी तथा करने वाले डॉक्टर अनंत जादव सर जी और अतिथियों का सुंदर इस प्रकार का परिचय देने वाले प्राध्यापक विक्रम धनवे जी, इनका भी मैं आभार व्यक्त करता हूँ। साथ ही इस कार्यशाला को भारत वर्ष से जुड़े हुए सभी प्राध्यापक गण, शोध छात्री, इनका भी मैं आभार व्यक्त करता हूँ और इसी आभार के साथ इस सत्र का समापन हुआ। धन्यवाद।
Thank you, sir. Thank you for your vote of thanks for the first session. Now, I would like to mention here to all the participants, this workshop will be run continuously without any break. Or workshop on the property rights, introduction and the registration process. Welcome to all in the second session. Now I would like to invite Dr. Mukundraj Patil sir, who is the IPSC coordinator of late Ramesh Vadpukar College, Sonpet, to give a brief introduction of this second session's keynote speaker, Dr. M.M. Bedkar sir. Please, Dr. Mukundraj Patil sir, over to you.
Thank you, ma'am. First of all, I welcome Dr. M.M. Bedkar sir as a keynote speaker, as well as I welcome Principal Dr. Dalve sir as a president of this session. Here, my duty is to introduce Dr. M.M. Bedkar sir, who is presently working as a principal, Sri Kumaraswamy Mahavidyalaya, Ausa. Sir has 29 years of teaching experience. He has published about 53 research papers at national and international level journals. He has also published a book entitled Simple Steps in SSR Preparation. Sir has 7 patents registered on his name. During his research work, Sir has visited different countries like Indonesia, Thailand, Singapore, etc., where he has read his papers and he has worked as a resource person also. Dr. Bedkar has given 47 invited talks on the patent system and NAC process. And very soon he will be complete his half century. I will congratulate him in advance. Congratulations, sir.
Thank you, sir.
He is Dr. Bedkar, sir, is a recognized research guide, and several students are working under his guidance for PhD. Again, sir are editor for different journals, as well as he has given talks on radio on different scientific issues. And due to such type of their decent contribution in the field of education and administration, he has received Principal of the Year award from IISR Kolkata and Best Teacher award from Gurukul Dream IAS Center. It's our great pleasure to have such a great personality among us as a research person. I cordially invite Dr. Bedkar, sir, to present his talk. Welcome, sir, and please proceed.
Thank you, sir. I am audible?
Yes, sir.
Thank you. Respected management authorities, Kadam Sahib, Deshmukh Sahib, respected principal, Dr. Satpute sir, late Ramesh Rao Varpkar, ACS College, Sonpet, principal of Sri Pandurang Paralegal College, Sirsala, and respected principal of Vasundhara College, Ghatnandur district, Bid. Today's resource person, respected Dr. Shirsat sir. I am student of Aurangabad, Dr. Babasaheb Ambedkar Marathwada University, Aurangabad, and he is from that university. So he is as like my guru. I read and watched all things today, and also watched his videos available on YouTube on the IPR. I have also learned so many things from his lecture, and thank you to respected Shirsat sir, and thank you to the college, all the IQAC members and authorities for giving me this opportunity to share my knowledge on this IPR. Objectives have covered by Dr. Shirsat sir, Satpute sir. So without going in detail to the objective of the program, I will start my lecture. I will try to finish it within the allowed time. Thank you, sir. Let us see the first slide. What is the objective of my presentation? Objective of my presentation is to know about IPs and IPRs. IPs म्हणजे काय, intellectual properties म्हणजे काय, त्याचे राइट्स काय आहेत. टू क्रिएट अवेअरनेस ऑन IPRs, त्याच्याबद्दल थोडीशी आपण जागृती करूयात. त्यानंतर टू नो द प्रोसेस ऑफ फायलिंग पेटेंट्स. ह्या 3 एक साध्या ऑब्जेक्टिव्ह असून मी सुरुवात करतोय, आणि या सर्व ऑब्जेक्टिव्हला आपण पुढे जाणार आहोत इंडेक्सच्या स्वरूपात. Index of my presentation is to know IPR, to know types of IPR, what is the IPR term, what are the IPR infringement, what are the IPR benefits, what is the patent, what is the patent filing process, what are the useful websites for filing the patents, few examples and news related to the patent section. Let us see the meaning of the first term I. In the word IPR, I is the first letter. What is I? I is the intellect, means thinking of a mind. एखादी व्यक्ती सतत विचार करते, प्रत्येक व्यक्ती, परंतु ती व्यक्ती विचार जी करते त्या व्यक्तीच्या विचाराला आपण इंटेलेक्ट असं म्हणतो. द इंटेलेक्ट मीन्स the things coming from a intellect mind which is thinking, and this person particularly is thinking to create a bulb which is shown in the side picture. Means the term I is the intellect from a mind. Second, if that intellect thinking is converted into a property that is known as intellectual property. The property here is shown as a symbol, as like a light bulb. So he has created a light bulb after thinking. So it is the intellectual property came from intellect mind. Thirdly, if we create intellectual property and not register on our name, so the persons from the society try to stolen your knowledge, try to take your knowledge, acquire your knowledge without your kind permission. These things happen before the registration of your innovation. After registration, what happens? After registration, you will be the owner of that property, and no one can stolen your knowledge. No one can use your knowledge without your permission, without giving a remuneration to you. So it's important to innovate, to create, to register that property on our name. So the rights given over the creations of a mind are known as the intellectual property rights. What are the rights? It is the given over the creation of our mind. आपल्या डोक्यामधून येणाऱ्या विचाराच्या प्रॉपर्टी रूपांतर जेव्हा रजिस्ट्रेशन होतं आपल्या नावावर, तेव्हा त्या रजिस्टर्ड व्यक्तीला जे अधिकार मिळतात त्याला आपण इंटेलेक्चुअल प्रॉपर्टी राईट्स असं म्हणतो. लेट अस सी दी टाइप्स ऑफ इंटेलेक्चुअल प्रॉपर्टीज. There are 7 types of intellectual properties. Detail have been explained by Dr. Shishak sir, but I will touch to that points because it is already in the PPT. Let us see the first type. It is the trademark. Trademark is what? It is the just pictorial symbol of a company which have to register in that patent office so that one can identify that this product is from that company. Means असे काही सिम्बॉल्स आहेत जे की रजिस्ट्रेशन करतात. ते रजिस्ट्रेशन केल्यानंतर त्या कंपनीला त्या मार्केटिंग करताना हा सिम्बॉल वापरायचा अधिकार मिळतो. अँड देर इज नो लिमिटेशन, नो एनी रिस्ट्रिक्शन टू क्रिएट अ ट्रेडमार्क. यू कॅन सी हिअर व्हरायटी ऑफ दिस सिम्बॉल्स नोन एज द ट्रेडमार्क. That is Jack Daniel, Coca-Cola, the Taste of India, Amul, Parle-G. All these are the varieties. There is no need to create special creation. So you can freely create a company that trademark and market their product. This is the first intellectual property. Secondly, trade secret. When a company organization is progresses. At that time, there is something hidden confidential matter which is helping to that company for progressing. That is known as the trade secret of that company. So any confidential business information like manufacturing secrets, commercial secrets, or any marketing secrets that are known as the trade secrets. If there is no need to registration because these are the secrets one. If someone have registered, then it will be known to the public. So these are the second intellectual property rights, that is the trademarks. Thirdly, before going to the third, let us see the what is the trade secrets. It is known to the limited peoples, those who are very nearer to the organization. There is no legal formalities are required to obtain the rights. त्याचे अधिकार घेण्यासाठी आपल्याला अधिकार नोंदवलं पाहिजे. ते जर नोंदवत नसेल त्याला अधिकार मिळण्याचा प्रश्नच नाही. So that you can just keep as a secret. And for an example, I will give few examples of the world. Those are the still known as the trade secrets. पहिला एक्झाम्पल आहे द गुगल सर्च अल्गोरिदम. आपण गुगलवर एखादा शब्द टाईप केल्यानंतर फ्रॅक्शन ऑफ सेकंड मध्ये लाखो रिझल्ट तो दाखवतो. याचा अर्थ काय? इट्स द अल्गोरिदम प्रिपेअर्ड बाय द गुगल अँड स्टील इट इज अ सिक्रेट फॉर दॅट वर्ल्ड. Second, Coca-Cola drink formula is also secret. And third, New York best seller, it is the best seller newspaper. So it's also secret for the world. So these are the few examples of the trade secrets. Let us go to the next slide. This is the third intellectual property, that is the geography indication. And Dr. Shishak sir have given examples of the basmati rice, Paithani, Kolhapuri chappal. These I am repeating here. What are the geography indications? Geographical indications are the man-made or natural products, those who can be registered under the geography indication as a proud of that area, and it helps to create the economy, to increase the economy of the area, and no one can from the world can claim that these are our product. This is our product. So it is the importance of registering geography indication. Let us see the few examples. Nagpur orange, basmati rice, Paithani, Paithanchi, Kullu shal, Nashik ki oily wine, Tirupati laddu. All these are the famous examples of the geography indications which India have registered, like Puneri pagdi, Kanchipuram sari, Kolhapuri chappal, Alpaso mango, Darjeeling tea. These are the geography indications registered by our India under the geographical indications as a third intellectual property. And there are 624 registered geographical indications from the India, and Karnataka is highest number of that is 23 registered by the Karnataka. So this is the third intellectual property. Let us share a story with you that as like sir Rasgulla was as like Sisa sir was saying that about the example of the gulab jamun, like the similar Rasgulla was the product from the Odisha, but other states were fighting or claiming that this is our product. So the company was committee was constituted, and that committee given the report that geographical indication for the Odisha Rasgulla is for the Odisha. So everyone trying to register geographical indications of their products of that area. Let us see the fourth intellectual property, that is the design or utility model. If someone designs 2D or 3D, then it can be registered under the design product, and once it is registered under design, it is the unique one, and it can give the commercial benefits to that designer. जसे इथं आपण उदाहरण पाहत असेल, एक दागिन्याचं मी चित्र दाखवलंय. असे दागिन्याचे चित्र ह्याच्यासाठी आहे की दागिना जेव्हा एखाद्या शॉपमध्ये आपण जातो, त्या सोन्याची किंमत 30,000 असते, परंतु दागिन्याची किंमत 1 ते 1.5 लाख होऊ शकते. त्याचं कारण काय, वरचे जे तो जे 1-1.5 लाख आपल्याकडून एक्स्ट्रा घेतो असतो, 1,20,000 तो त्याच्या डिझाईनचे घेतो. सो डिझाईन इफ इट इज युनिक वन, सो इट कॅन बी सेल विथ सो मेनी कॉस्ट. So design is the fourth design or utility model is the fourth intellectual property. Now let us see the fifth intellectual property, that is the plants breeder right. Means some factories or some farmers, if they have created some new variety of the plant or the seed using biotechnology, cutting, tissue culture, so they can get benefited under the plants breeder right. They can register their intellectual property under plants breeder right. So this is the fifth intellectual property. And the sixth intellectual property is the copyright. As like Dr. Shirshak sir have given detail about that, it is a tangential property, and painting, audio, video, CD, all these things, books, this tangential property can be registered under the copyright. Let us see one example of that. If you see the copyright protection commences from the moment ID is created, जेव्हा त्याचा पब्लिसिटी झाली तेव्हा त्याला कॉपीराइट मिळू शकतात, अँड इट्स ऑप्शनल. तुम्ही रजिस्टर करा अथवा करू नका, तो तुमचा ऐच्छिक भाग आहे, पण तो रजिस्टर करणं हे चांगलं. इथे एक मी उदाहरण देतोय. बॉम्बे टू गोवा नावाच्या फिल्मचं पहिलं चित्र आहे. तिथे तुम्ही पाहत असाल जारी करने की तारीख, समाप्त करने की तारीख, these are the two dates have mentioned here. So within this span no one can give the name to the film Bombay to Goa. बॉम्बे टू गोवा या काळामध्ये कुणी देऊ शकत नाही, कारण तो कॉपीरिटन नेम आहे, तेवढ्या काळापुरता ते प्रमाणपत्र सांगतं. तसं तुम्ही पाहिलं असेल खाली 3 चित्र आहेत, एक डॉन आहे, डॉन 1, डॉन 2, डॉन 3. जर त्याच्या काळामध्ये जर आपल्याला फिल्म काढायची असेल तर त्याच नावाला सिमिलर असलेल्या नावामध्ये थोडासा बदल करू म्हणून अशी डॉन 1, डॉन 2, डॉन 3 अशा फिल्म्स येतात. त्याच्या नेमची प्रायोरिटी संपण्याच्या अगोदर असं नाव थोडं बदलावं लागतं, परंतु प्रायोरिटी संपल्यानंतर मात्र आपल्याला पुन्हा ते नाव देता येतं. दिस इज द इम्पॉर्टन्स ऑफ द कॉपीराइट. Let us see the seventh intellectual property, that is the patent. What is patent? It is a monopoly right granted to a person who has invented a new novel and useful article. सरांनी फार डिटेल सांगितलेलं आहे. हा एकत्वाचा अधिकार आहे, स्वामित्वाचा अधिकार आहे. ज्या व्यक्तीला किंवा ग्रुप ऑफ व्यक्तीला इन्व्हेंशन केले, काय इन्व्हेंशन केल्याचं नवीन किंवा नाविन्यपूर्ण असं उपयोगी आर्टिकल ज्यांनी निर्माण केलेलं आहे, किंवा इट कॅन बी इम्प्रुव्हमेंट ऑफ अन एक्झिस्टिंग आर्टिकल. नवच असं काही बंधनकारक नाही. जर इम्प्रुव्हमेंट तुम्ही दाखवला तरी तुम्हाला त्याचं पेटंट म्हणून ग्राह्य धरलं जातं. किंवा द न्यू प्रोसेस ऑफ मेकिंग अन आर्टिकल, इफ द आर्टिकल इज सेम बट प्रोसेस ऑफ मॅन्युफॅक्चरिंग इज डिफरंट, देन इट कॅन बी ग्रँटेड फॉर अ पेटंट ऑल्सो. सो व्हॉट इज पेटंट? It is a monopoly right given by the government, given to the person or group of persons who have invented a new, novel and useful article, or it may be improvement of an existing article, or it may be new process of making the same article. So article should be capable of industrial application. This is must. If there is no application in the useful application, one. Let us see the 3 parts of the patents which are most required. First of all, novelty. There should be novelty, there should be inventiveness, and there should be utility. Then only we can define its a patent. So patent should have novelty, inventiveness and utility also. Let us see an example of the wheel. इथे मी चाकाचं उदाहरण दिलंय. चाकाचं उदाहरण पहिल्यांदा तो दगडी चाक होता, नंतर लाकडी चाक आला, नंतर आरे असलेला आला, नंतर त्याला कोटिंग आली, नंतर त्याला ट्यूब आली, नंतर त्याला ट्यूबलेस झाला. So these are the improvement in a single article wheel. So every time it is able to got a patent. Every time it is applicable for the patent. So this is the simple example. It is the improvement in an existing article. चाक दगडाचा होता, तो लाकडाचा का झाला हे आपण सांगितलं. ऑब्जेक्टिव्ह त्याचं असं वजन कमी करण्यासाठी, नंतर पुन्हा अजून वजन कमी करण्यासाठी, पुन्हा त्याला स्मूथनेस यावं म्हणून इझी जावं, ह्या सगळ्या प्रकारच्या इम्प्रुव्हमेंटचा आपण अभ्यास केल्यानंतर प्रत्येक वेळेस इम्प्रुव्हमेंट झालेली आहे. सो दॅट द सेम आर्टिकल कॅन बी अप्लाइड फॉर द पेटेंट इफ इट इज इम्प्रूव्ड innovatively. Let us see the patentable inventions. आपल्याला आयट म्हणजे काय कळलं, IPR म्हणजे काय कळलं, इंटेलेक्चुअल प्रॉपर्टीचे प्रकार कळलेले आहेत आपल्याला. आणि त्यानंतर आपण जाऊया which things are patentable. कुठल्या गोष्टीचं पेटेंट घेता येतं. फर्स्ट ऑफ ऑल मशीन, apparatus or other articles can be patented. ज्या गोष्टी मशीन्स आहेत, apparatus आहेत, इक्विपमेंट्स आहेत, उपयोगी आहेत, इनोव्हेटिव्ह आहेत, नाविन्यपूर्ण आहेत किंवा इम्प्रुव्हमेंट आहे, अशा सर्व मशीनचं आपल्याला पेटेंट घेता येतं. Secondly, the process of method of manufacture. Any process of making of a same article can be granted as a patent. जसे एखादी पॅरासिटामॉल गोळी आहे, अनेक कंपन्यात सेम नाव देतात, परंतु ते सिंथेसिस प्रोसेस डिफरंट असते. मग अशा वेळेला आपण काय करतो, प्रोसेसला पण पेटेंट देतो. जशी एखादी कार आहे, पहिल्यांदा कार कशाची होती, डिझेलची होती, नंतर पेट्रोलची आली, नंतर पुन्हा पेट्रोल डिझेल, नंतर गॅस कार आली, नंतर हायब्रिड कार आल्या, इलेक्ट्रिकल कार आल्या. These are the improvements in the same article, but every time it is a new one, so that the process is different, so that the process of the manufacturer can be granted for a patent. Now the software, if the software is used for the hardware to run the hardware, then it can be granted. A single software without running to the hardware can be copywritten. Let us see the food products, chemical, medicines or drugs. These all can be patented if they lose their original property. Means there is a new innovative product from the reaction, chemical reaction of that ingredients. Then and then only we can grant it for the patent. Now, after seeing the patentable thing, let us see the non-patentable. कशा कशाचं पेटेंट घेता येत नाही ते पण आपल्याला पाहिलं पाहिजे. फर्स्ट ऑफ ऑल नोन इन्व्हेन्शन्स, जसं सरांनी सांगितलं ऑब्वियस, जे जगाला माहिती आहे त्याचं पेटेंट आपल्याला घेता येत नाही. सो फर्स्ट ऑफ ऑल नोन इन्व्हेन्शन्स कॅन नॉट बी ग्रँटेड. सेकंड, इन्व्हेन्शन कॉन्ट्रॅरी टू नॅचरल लॉ, नैसर्गिक नियमाच्या विरुद्ध काम करणाऱ्या कुठल्याही शोधाचं पेटेंट घेता येत नाही. सेकंडली, इन्व्हेन्शन्स कॉन्ट्रॅरी टू द नॅचरल लॉ दॅट कॅन नॉट बी पेटेंटेड. थर्ड, दी अगेन्स्ट पब्लिक इथिक्स अँड मोरॅलिटी, जगाच्या लोकांच्या आदर्शाच्या विरुद्ध काम करणाऱ्या अशा कुठल्याही शोधाचं पेटेंट घेता येत नाही, अगेन्स्ट पब्लिक मोरॅलिटी अँड इथिक्स. अँड फोर्थ, कॉझिंग कमर्शियल एक्सप्लॉयटेशन, ज्याचा उद्देश पिळवणूक करणे असा उद्देश ठेवून जर ती वस्तू बनली असेल तर त्या वस्तूचं पेटेंट आपल्याला घेता येत नाही. पेटेंट कॅन नॉट बी ग्रँटेड टू दोज हू हॅव ऑब्जेक्टिव्ह एज कॉझिंग द कमर्शियल एक्सप्लॉयटेशन. नाउ फिफ्थ, द हार्मफुल थिंग्स टू द ह्युमन, ॲनिमल, प्लांट लाईफ ऑर एन्व्हायरमेंट, ज्या गोष्टी कशा कशाला कारणीभूत आहेत, व्यक्तीच्या जीवनासाठी, आरोग्यासाठी, प्राण्यांच्या, प्लांटच्या आणि एन्व्हायरमेंटच्या, या सर्वांना धोक्यात आणणारी एखादी वस्तू असेल, शोध असेल, अशा शोधाचं पेटेंट घेता येत नाही. द थिंग्स विच आर हार्मफुल टू हेल्थ, ह्युमन अँड ॲनिमल, प्लांट लाईफ ऑर एन्व्हायरमेंट कॅन नॉट बी ग्रँटेड फॉर अ पेटेंट. And sixth, discovery of scientific principles, those which are known to us that cannot be granted for a patent. And substances obtained by just admixture, एखादा admixture असेल ज्याच्यामध्ये कुठलीही केमिकल रिएक्शन झाली नाही, फक्त रंग बदलला, स्वाद बदलला, म्हणून त्याचं पेटेंट घेता येत नाही. जसं लिंबू सरबत आहे, लिंबू सरबत म्हणजे साखर, लिंबू, लिंबाचा रस, मीठ आणि पाणी असं आपल्याला मिक्सचर असतं. ते त्याचा स्वाद वेगळा होतो, कलर वेगळा दिसेल तुम्हाला, परंतु the products can be filtered after chemical reaction. These are not reacted. त्यांचं रिएक्शन झालेलं नाही, एकजूट झालेलं नाही, त्यापासून कुठलाही नवीन असा प्रॉडक्ट आला नाही. म्हणून substances obtained by just admixtures cannot be patented. There should be innovative product from that reaction. And eighth, the plants, animals and whole or any part, कुठल्याही वनस्पतीचं, प्राण्याचा, त्याचा कुठल्याही भागाचा आपल्याला पेटेंट घेता येत नाही. प्लांट्स, एनिमल्स इन होल ऑर एनी पार्ट, बिकॉज दे आर नॅचरली बॉर्न, दे आर नॅचरली produced and they are naturally growing. So no one can claim patent on a plant or animal or any part of that. And नंबर 9 मेथड ऑफ मेडिकल क्युअर. निदान करण्याच्या कुठल्याही पद्धतीचं पेटंट घेता येत नाही. निदान करण्याची पद्धती जगासाठी फ्री ठेवलेली आहे, त्यातून कोणाचे पिळवणूक होऊ नये. म्हणजे इथं जे तुम्ही चित्र पाहत असाल, एका बाळाला तपासताय डॉक्टर, तपासण्याची पद्धत जी आहे ती पद्धत पेटंट घेता येत नाही. And the thermal scanning process is not patented, but these equipments used for the like stethoscope and the thermal scanning machine, these are the equipments can be patented. Means method of medical cure cannot be patented, but the equipments used in the medical sector can be patented. Now 10th, the method of agriculture or horticulture कल्टिवेशन करण्याच्या कुठल्याही पद्धतीचं पेटेंट घेता येत नाही, परंतु कल्टिवेट करण्याची जी इक्विपमेंट आहे, शेतकऱ्यांची जी काही मळणी यंत्र, धुळणी यंत्र, फवारणी यंत्र आहे, पेरणी यंत्र आहे, ह्या सगळ्या यंत्राचं पेटेंट घेता येतं. बट द मेथड ऑफ द कल्टिवेशन, इतके फुटावर लावला पाहिजे, इतक्या अंतरावर लावला पाहिजे, इतक्या दिवसांतर असं करायला पाहिजे, ही जी टेक्निकल आहे बाब, त्या बाबीचं मात्र पेटेंट घेता येत नाही. नंबर 11, ट्रेडिशनल नॉलेज कॅन नॉट बी पेटेंटेड. आपल्याकडे जे ट्रेडिशनल नॉलेज उपलब्ध आहे, जगांना माहिती आहे, लोकांना माहिती आहे, त्या गोष्टीचं आपल्याला पेटेंट घेता येत नाही. आणि म्हणून हळदीचं जे आपलं पेटेंट जे अमेरिकन घेतलं होतं ते केवळ या गोष्टीवर आपण माशेलकर साहेबांनी आदरणीय परत घेतलं की आमच्याकडे ते पुरातन काळापासून ते ज्ञान इथं उपलब्ध आहे, म्हणून ट्रेडिशनल नॉलेज कॅन नॉट बी पेटेंटेड. अँड देन atomic energy inventions can be patented. ज्याला कोणाला atomic एनर्जीवर काही संशोधन करायचं आहे त्यांनी पेटेंट दाखल करण्यापूर्वी दिल्लीच्या atomic एनर्जी विभागाची परवानगी घ्यावी लागते. इन जनरल की atomic एनर्जी इन्व्हेन्शन सामान्य माणसाला पेटेंट घेता येत नाही, विशेष परमिशन अशी घ्यावी लागते. आफ्टर the knowing what are patentable, what are not patentable thing, let us go to the infringement. जेव्हा एखादी गोष्ट मार्केटमध्ये येते तेव्हा त्या गोष्टीचं डुप्लिकेशन करणं, त्याचं उत्पादन कमी करणं मूळ कंपनीचं, ह्या सगळ्या सामाजिक ज्या विकृती आहेत त्या चालू होतात. अशा वेळा मग आपण काय म्हणतो की इट्स द पेटेंट डुप्लिकेटेड बाय समवन, मार्केटेड बाय समवन, सो दॅट काइंड ऑफ इन्फ्रिजमेंट हॅपन्स इन दिस सोसायटी. सो दॅट टाइप ऑफ इन्फ्रिजमेंट कॅन बी सीन इन दी IPR. व्हॉट इज द इन्फ्रिजमेंट इन IP? जसं आपण इन्फ्रिजमेंट इन एन्क्रोचमेंट म्हणतो, प्लॉट मध्ये एखादी 5 फूट जागा कमी जास्त करणे, रोड साईडला हे ते सगळ्या गोष्टी, त्याला आपण एन्क्रोचमेंट इन फिजिकल प्रॉपर्टी म्हणतो. परंतु पेटेंटच्या क्षेत्रामध्ये जर असं जर होत असेल, डुप्लिकेशन होत असेल, तर त्याला आपण काय म्हणतो, इन्फ्रिजमेंट म्हणतो. इन्फ्रिजमेंट काय? मग इन्फ्रिजमेंट इज द अनऑथराइज्ड यूज, कुठल्याही परवानगीशिवाय त्याचा वापर करणे, डुप्लिकेशन करणे, सेल ऑफ द डुप्लिकेट मटेरियल, एखाद्या फेमस प्रॉडक्टचं डुप्लिकेशन करून विकणे, आणि तेव्हा त्याला या इन्फ्रिजमेंट असं म्हटलं जातं आणि तिथे शिक्षेची पण तरतूद आहे. लेट अस सी दी एक्झाम्पल, 3 एक्झाम्पल. One of the similar, these are the similar but not same. Okay, Oakley, Colgate, Bilseri, Distillery. These are the 3 products made duplicate by someone. So one cannot identify if he not observed clearly. So these some companies are trying to duplicate, trying to infringement. So that is known as the infringement. Let us see an example of the infringement. Fine to the Samsung company. Apple have fined more than $1 billion to the Samsung company because of the Samsung company have copied some crucial features of the iPhone. So international court, it is fined more than $1 billion. Here is one example of the copy return case which is filed in the Delhi court. It was the dress designed by the designer and having the copyright, and in that period she have violated the law, and in Delhi court she have fined of 2 crore suit for that punishment. So let us see what we can do with the IPR. जसं आपल्याला शेषा सरांनी सांगितले की आपली फिजिकल प्रॉपर्टी, टॅन्जिशियल प्रॉपर्टी ही आहे, तशाच पद्धतीने व्हॉट कॅन वी डू ड्यू IPR? आपल्याकडे IPRचं रेजिस्ट्रेशन सर्टिफिकेट आहे, तर त्याचं काय आपण करू शकतो? व्हॉट कॅन डू विथ दी IPR? इट इज नॉट फिजिकल प्रॉपर्टी बट इट इज प्रॉपर्टी विथ सर्टिफिकेट, मीन्स टॅन्जेन्शियल प्रॉपर्टी. लेट अस सी, फर्स्ट ऑफ ऑल वी कॅन असाइन दी IPRs. आपल्याकडे असलेलं IPR आपण काय करू शकतो? प्रमाणपत्र काही दिवसासाठी असाइन करू शकतो आर्थिक फायद्यासाठी. सो ॲज लाईक आवर फिजिकल प्रॉपर्टी वी कॅन असाइन दी आवर IPR, इंटेलेक्चुअल प्रॉपर्टी. सेकंडली वी कॅन सोल्ड दी इंटेलेक्चुअल प्रॉपर्टी ॲज लाईक आवर फिजिकल प्रॉपर्टी. व्हाय इट इज द प्रॉब्लेम ऑफ, इफ यू वॉन्ट टू टेक बेनिफिट ऑफ दॅट IPR by selling it. You can sold it, and after that, the person which you have sold, he can enjoy or she can enjoy the benefits of the IPR. And lastly, you can gift the IPRs. IPRs can be gifted also, like our physical property, and after gifting to that person, that second person can use or can enjoy the benefits of the IPR. So IPR can be assigned, IPR can be sold, IPR can be gifted. As like our physical property, we can gain commercially, we can sold, we can take commercial commercial benefits from the IPR also. Now let us see a few examples of the patent. What are the examples of the patent? I have quoted here some funny and few simple examples of the patent. It's the anti-eating face mask. One doctor has recommended to a person not to eat frequently. So it's just a mask having the argument you are seeing on the screen, just to avoid the eating in between within the time. So that is the anti-eating mask. हा फक्त तोंडाला तो अनेक वेळा खाऊ नये म्हणून डॉक्टरने केलेला मास्क आहे आणि तो मास्क सुद्धा पेटेंटेड आहे. हा अत्यंत साधं उदाहरण आहे. सेकंडली, पेटेंट ऑन बॅक स्क्रॅचिंग. पाठ काढणे हे काही नवीन नाही, परंतु ते पाठ काढत असताना आपल्याला असं वाटतं की काहीतरी इक्विपमेंट राहावं जेणेकरून आपल्याला हा त्रास कुणाच्याही मदतीशिवाय आपण कमी करू शकतो. अशा वेळेला त्या संशोधकाला वाटलं की असं एखादी मशीन तयार करावी जेणेकरून या गोष्टीचा पेटेंट घेता येईल आणि त्यांनी ते पेटेंट घेतलेलं आहे. सो दीज आर द व्हेरी सिम्पल फनी एक्झाम्पल्स ऑफ द पेटेंट. नॉट टू थिंक सो मच हाय लाईक व्हेरी हार्ड थिंग्स टू हॅव अ पेटेंट. पेटेंटसाठी फार मोठ्या गोष्टीची गरज नाही, ते सांगण्यासाठी मी या दोन गोष्टीचं उदाहरण दिलंय. आणि तिसरं एक उदाहरण आहे, एखाद्या ऑफिसमध्ये काही कर्मचारी असतात ज्या कर्मचाऱ्यांना अधिकाऱ्यांनी काम सांगितले काम करू वाटत नाही, पाय दुखलाली, कंबर दुखलाली, असंच काहीतरी वेगवेगळी कारणं सांगतात आणि कामाला टाळायचा प्रयत्न करतात. तसं एखाद्या परदेशातल्या त्या व्यक्तीला असं वाटलं की आपण एखादी मशीन काय डेव्हलप करू नये ज्याच्यावर पेटेंटही घेता येईल आणि ट्रीटमेंटही देता येईल. मग त्यांनी एक पेटेंट डेव्हलप केला, त्याला नाव दिलं हेडॅक व्हील लिस्ट. हेडॅक व्हील लिस्टमुळे ज्याचं कुणाला असं पाठदुखी, कंबरदुखी वगैरे त्रास सुरू झाला काम सांगितल्यामुळं, तशा त्या कर्मचाऱ्याला आणून तो व्यक्ती अशा प्रकारची ट्रीटमेंट द्यायला लागला आणि त्यानंतर मग लोकांनी सायकोलॉजिकली ही ट्रीटमेंट घेण्यापेक्षा काम करणं बरं असं वाटलं आणि मग त्या पेटेंटचा फायदा झाला. ही गॉट ऑल्सो पेटेंट and he also received high efficiency of the office also. This is the funny patent I have collected. Now this is the last funny patent. It is an eye protector for chickens. आता कोंबडी आणि चष्म्याचा तसा काही संबंध नसतो, परंतु काहीतरी ऑब्जेक्टिव्ह टाकून त्या कोंबडीचा चष्मा कसा असावा, तो कसा बसला जावा, काय उपयोगाचा आहे अशी थेरी डेव्हलप करून 1903 साली एक पेटेंट दाखल केलं गेलं. त्याचं नाव होतं आय प्रोटेक्टर फॉर चिकन, कोंबडीचा चष्मा. अशा प्रकारचे फार मोठे शोध नाही, परंतु लहान लहान शोधामधून सुद्धा आपल्याला पेटेंटकडे जाता येतं हे एवढं या उदाहरणातून आपल्याला लक्षात येईल. एक शॉप आहे ज्याचं नाव आहे पेटेंट धार केंद्र. कराडला बस स्टॉपच्या समोर एक गल्ली आहे, त्या गल्लीमध्ये ह्याचं नाव आहे पेटेंट धार केंद्र. त्या व्यक्तीला मी भेटलो, म्हणजे सहज दिसलं म्हणून मी विचारलं का रे बाबा तू नाव का दिलं असं. तर त्यांनी सांगितलं की आम्ही या धार लावण्याच्या क्षेत्रामधले, हत्यारांना धार लावायच्या क्षेत्रामध्ये तो ऊसतोडीचा व्यवसाय चालतो. आम्ही इतके तरबेज आहोत की आमची लावलेली धार बरेच दिवस टिकून राहते, म्हणून लोकांचा ओढा आमच्याकडे आहे आणि आमच्याकडे खूप रश असते असं त्याला सुचलं दिसलं आणि मग त्यांनी दुकानाचं नाव दिलं पेटेंट धार केंद्र. लेट अस सी देर आर ग्रेट वंडर्स ऑफ द फील्ड ऑफ द पेटेंट. असे कुठले जगातले आश्चर्य आहेत पेटेंट क्षेत्रातले की जेणेकरून जगाचा कायापालट झाला. दीज आर द 8 वंडर्स ऑफ द इन द फील्ड ऑफ द पेटेंट. लेट अस सी. 1 लाईट बल्ब, 2 इंटरनल कंबशन इंजिन, 3 टेलिफोन, कॉम्प्युटर, Bluetooth technology, the Maglio technology, the FireEye malware system, and Google PageRank. These are the inventions which are affected on the high progress of all the world and known as the great 8 wonders of the patent. After seeing the patent, definition of patent, what can be patented, what cannot be patented, and some examples of the patent after seeing, we go toward the filing of the patent. Let us go toward the filing of the patent. First of all, we have to write down the idea as much detail as possible, maybe roughly, but we have to write as detail as possible the idea of the patent. This is the first step before filing the patent. Secondly, after filing the patent, we have to check for the patentability subject matter. म्हणजे आपण एवढी सगळी मेहनत केली आणि त्याचा पेटेंटच घेता येत नाही. जसं आपण वर पाहिलं, काही गोष्ट पेटेंट घेता येतं, काही गोष्ट पेटेंट घेता येत नाही. इफ आवर सब्जेक्ट मॅटर इज अंडर नॉन पेटेंटेबिलिटी, देन दी आवर ऑल एक्झिस्टन्स गेट्स लॉस्ट. आपलं सगळं मेहनत वाया जाईल. म्हणून सेकंड थिंग अशी करायची आपल्याला की इट्स द पेटेंटेबल ऑर नॉट, वी हॅव टू चेक इट फॉर दॅट. And नंतर if it is confirmed, then you can go ahead for the filing of the patent. Let us write down the rough matter, maybe rough, but you have to detail write down the idea. Then secondly, you have to check the patentability subject matter. If it is patentable, then go for the filing the patent. And if you got some commercial value of that, if you think that it's the commercial one, you can go easily for filing a patent. So after deciding that we have to file the patent, there are again 3 steps. First step is searching. Searching means what? We have to search the related patents on this searching website, searching engines. As like our writing of the research paper, we give some references on the internet available or anywhere available. Like that, we have to search the related patents of that, which is most nearer to us, which is more nearer to our invention. And then second step is drafting. Drafting is more important, as like searching. And third is the sending one. After drafting the patent in a proper format, we have to send the patent. Let us see one by one. First of all, steps for the searching. We have to first step searching of the patent on the search website. There are 5 search engines I have noted here. There are thousands of patents, lakhs of patents available on the search engine. We have to search our title on that, which is most related to us. We have to collect it. 20 or 10 to 30, 10 to 20 patents are sufficient for that, to give the reference for that. And we have to say that our patent is different from that. We have improved this much. This is the references you can get from the search website, that is Google Patents, USPTO patent, full text and image database. INPAS, it is the Indian Patent Advanced Search System, then ESPC Net System, and then WIPO, World Intellectual Property Organization. These 5 websites are sufficient to grant a patent. So the participants can note these 5 websites and they can use this website to search that title, which can give most nearly patents of your invention. Let us see one example of a pen. पेन हा रोजचा उपयोगाचा आपल्याला वस्तू आहे. ह्या पेनचा शब्द जर शब्द तुम्ही जर आपण सर्च इंजिन मध्ये टाकलं तर काही महिन्यापूर्वी मला किती पेटेंट मिळाले याच्यावरचे? 1,62,225. सो सिंपल पेन इज ऍडव्हान्स्ड or patented 1,62,000 more than 1,62,000 times. Every time it is improved and issued a patent or granted a patent. म्हणजे आपल्या सोबतच्या, आपल्या सहकार्यासोबतच्या किंवा आपण वापरत असलेल्या कुठल्याही वस्तूचं आपलं पेटेंट घेता येतं. आता हा चष्मा आहे, या चष्म्याचं गॉगलचं पेटेंट घेता येतं. आपल्याला वाटतं याचा अगोदर पेटेंट झालं असेल, होऊ शकतं. पेनवर सुद्धा लाखो पेटेंट आहेत, तरी तुम्हाला अजून एखादी त्याला इम्प्रूव्ह केलं तर तुम्हाला पेटेंट मिळू शकतं. सो इफ इट इज नॉट न्यू, देन यू कॅन यूज पेटेंट फॉर इम्प्रुव्हमेंट ऑफ एन एक्झिस्टिंग आर्टिकल. नाउ let us see the second step, it is the drafting. Drafting is important because we have to read the patents which are most nearer related to us, and we can learn the language of drafting. It is techno-legal language. We have to write very particularly, and so that we can get idea by reading patents from that. And second step is the drafting. So drafting is important, and we can draft the patent if you read some few patents of our related thing. Now, what is the structure of a patent application? As like our research paper, there is objective, then introduction, then methodology, calculations, graphs, charts, and then conclusion. Like that, the structure of the patent application is like that. Title of the invention, we have to write unique title of that. Secondly, the subject matter. Subject matter covers the background of the invention. What is the background of our invention? We have to write in detail. The prior art details. Prior art details means how much patents have published on the same theme. We have to refer for that. And then we have to give object of invention. What is the objective of our invention? And D is the important. Detailed description with drawing characterization which can support your patent to explain every line of that draft. So that you have to give in detail. And E number is the claims. As like Dr. Sirsat sir said, claims are very important. We have to write very carefully claims. If we lose some invented thing without writing the claim, then someone get the ready-made material to file a patent if we not write claims properly. And then after searching, after drafting, the third step is sending. Where to send the patent? There are 2 types of sending. First of all, manual sending means just downloading the form by courier, by post, or by register. You can send your form. And secondly, e-sending. E-sending means by downloading form, then typing that form and sending e-type submission. You can send. You can pay the fee also through e-submission also. So in this period, e-submission is more easy than manual sending. This is the Corona period. That was the Corona period. So it was very easy to send our patents by e-type also, and both are equally important. One can send manually or one can submit e-type also on the website ipindiaonline.government.in EPATEN फिलिंग पेटेंट फिलिंगची ही वेबसाईट आहे. या वेबसाईटवर आपण ई फायलिंग करू शकतो. म्हणजे विदाउट गोईंग आउट ऑफ आवर होम वी कॅन, विदाउट गोईंग आउट ऑफ आवर ऑफिस वी कॅन सबमिट पेटेंट विदाउट एनी एक्झर्शन. नाउ वेअर टू सबमिट. आपण पेटेंट तयार केलंय, सबमिट करायचं ठरले, कुठं सबमिट होऊ शकतो. पेटेंट कॅन बी सबमिटेड इन दी 4 ऑफिस: मुंबई, चेन्नई, न्यू दिल्ली अँड कोलकाता. दिस इज अ ज्युडिशियल एरिया. फॉर महाराष्ट्र इट इज मुंबई, for South it is Chennai, and for Delhi it is North India. For Delhi and other states can use the Kolkata. So for Maharashtra we can submit our patent in Mumbai office. Okay, after seeing for that patents where we can submit, now there is question in our mind that who can submit a patent application. Patent application कोण सबमिट करू शकतो? प्राध्यापक करू शकतो का? रिसर्च गाईड सबमिट करू शकतो? काय सायंटिस्ट सबमिट करू शकतो? कोण सबमिट करू शकतो? हा आपल्या डोक्यापुढे प्रश्न असेलच. तर तो प्रश्न आपण आता सोडूया. हु कॅन सबमिट द पेटेंट application? नंबर 1, patent application can be submitted by the applicant himself, ट्रू और फर्स्ट इन्व्हेस्टिगेटर. त्याला असं ट्रू किंवा फर्स्ट इन्व्हेस्टिगेटर म्हणतात. तो स्वतः सबमिट करू शकतो. सेकंडली, इट कॅन बी फिल्ड जॉईंटली कशासाठी? जेव्हा एखादा रिसर्च गाईड असतात, त्यांच्या सोबत रिसर्च स्कॉलर्स असतात, या सर्वांनी मिळून त्या पेटेंटची माहिती केलेली असते तयार. अशा वेळेला जॉईंटली कॅन सबमिटेड द पेटेंट. थर्डली, थ्रू अँड असाइनिंग. एखाद्याला आपण अधिकार पत्र दिलं आणि घरी आराम जरी केला आणि त्याला पत्र दिले की दिस पर्सन इज कमिंग, प्लीज फाइल माय पेटेंट ऑन माय नेम असं म्हटलं तरी असाही सुद्धा तुमचा पेटेंट घर बसल्या दाखल करू शकतो. नंतर थ्रू अथॉरायझ्ड IPR एजंट. जसं डॉक्टर शिरसाट सरांनी सांगितलं की जेव्हा आपण वाटतं की आपल्याला मदत घ्यावी, तर अशी मदत कुणाची घ्यायची? तर IPR एजंटची. आता IPR एजंट म्हणजे कोण असतात? These are the qualified persons which have applied for the examination of patent office and they have licensed to guide the persons for filing a patent. असं गाईड करण्यासाठी ज्याकडे लायसन आहे अशा IPR एजंट कडून आपण पेटंट दाखल करू शकतो. आणि 5वी, अंतिम इच्छा. समजा एखादा व्यक्ती दुर्दैवाने पेटेंट तयार केला आणि वारला, तर अशा व्यक्तीच्या सुद्धा लिगल वारसा करून पेटेंट दाखल करता येतो. म्हणजे पेटेंट दाखल करण्यासाठी कुठलाच अडथळा नाही. फक्त आपल्याकडे काय पेटेंट तयार असणं महत्वाचं आहे. इट शुड बी रेडी फॉर द पोस्टिंग और सेंडिंग टू द पेटेंट. सो फिफ्थली इज दैट वन कैन सेंड द पेटेंट आफ्टर हिज और हर डेथ also. So any legal representative of any dead person can file a patent. After seeing what is patent, what are the types of who can file a patent, let us see पेटेंट फायलिंग फॉर्म्स अँड फीस. पेटेंट फायलिंगला असे किती फॉर्म लागतात, किती फीस लागते याची आपल्याला कल्पना राहावी. तर त्याला फक्त 4 फॉर्म लागतात. फॉर्म नंबर 1, फॉर्म नंबर 2, फॉर्म नंबर 9 अँड फॉर्म नंबर 18. अँड दिस इज द करस्पॉन्डिंग फी. 1,1600, 2,500 अशी फीस असते. देर आर सो मेनी फॉर्म्स अवेलेबल ऑन द इंटरनेट on the intellectual property right office, but these are the 4 forms are necessary for granting a patent. Other forms are required for other purposes. First form is the application for the patent. Where to do application? Secondly, we have to file complete specification. What is complete specification? I will explain later on. Third is the request for publication. Once we have filed, we have to request for the publication by paying the fees. After publication, we have to request for the examination after paying this type of fees. So there are the 4 forms required. It is necessary for granting a patent. Then types of the forms. Types of filing of the patent. Let us see there are how many types of filing a patent. There are 2 types of filing a patent. First of all, it is the provisional one, and second is the complete one. What is the provisional one? If you have an idea in your mind but you have not detailed that idea in your mind. You are not your reports or chemical synthesis or characterization with you. Then you can register your article as like a provisional patent to the patent office. Means first of all we have to search, first of all without searching, without doing anything, just we have to search the title, just write some abstract, and just registration of our title is the provisional registration. And in the provisional registration you use only form number 1 and the particular some fees of 2,500, and you can write down the title and just a small abstract. This is the provisional type of submission of the patent application. But provisional type of submission of the application cannot be granted for the patent. But within 1 year, we have to apply for the complete specification within 1 year, or maybe extended by paying some fees for a few months. So within the 1 year, we can file. We have to file the complete specification with form number 1, form number 2, form number 9, form number 18, and the fees with detailed draft, drawing, and sketches. If someone failed to file the complete specification, then provisional application lapsed. So that we have to file complete specification within 1 year. So there are two types of filing. One is provisional and second is complete. There is no need to file provision. Let us see. There is no need to file provision. You have complete provisional provision in your mind, then you can file complete patent your idea in your mind, complete detail your mind. You can go for the complete specification also. Let us see the process of after submission. What happens after submission? Patent office publishes the application. Publish the application if you have paid the fees. Then first examination report issued from the patent office, where they have some queries or questions. We have to give satisfactory answer to the first examination report FER to the office within 1 year. And if the patent office is satisfied with that answer, then they can issue the patent certificate, or they may call for the interview also if there was again doubt in their mind. So submission, publication, first examination report, filing, first answer to the first examination report, and the issue of the patent certificate. These are the 5 steps we have to face after the submission of the patent. And then after granting the patent, you don't be relaxed after granting a patent. जसं शिरसा सरांनी सांगितलं की काही फीस असते, ती फीस टाइमला भरली तर पेटंट आपल्या नावावर राहतो, नाही तो पेटंट लॅप्स होतो, गव्हर्नमेंटला जातो, आपल्याला कुठले अधिकार मिळत नाही. सो दॅट डोंट बी रिलॅक्स आफ्टर गेटिंग ए पेटंट. लेट अस वी हॅव टू रिन्यू इट. आता रिन्यू करण्याचे टर्म्स आणि कंडिशन्स आहेत. काय किती वर्ष टर्म रिन्यू करता येतं बघा. ते पेटंट 20 वर्ष रिन्यू करता येतो, त्याच्या पुढे नाही. कॉपीराइट हा 70 वर्ष म्हणजे लाईफ त्या व्यक्तीचा असेपर्यंत, आणि 70 वर्ष. डिझाईन 15 वर्ष आपल्याला रजिस्टर्ड करता येतात, त्याच्या पुढे नाही. पेटंट प्लांट्स बिल्डर राईट 15 वर्ष. जसं 15 वर्षापूर्वी एखादं कापसाचं बीटेक बियाणं आलं, ते बियाणं 15 वर्षाच्या नंतर ते मार्केटसाठी खुलं होतं, कुणी प्रॉडक्ट करू शकतो, उपयोग करू शकतो. परंतु ट्रेडमार्क हे फक्त 10 वर्ष लाईफ असते, परंतु जर रिन्यू केलं तर ते अनेक वर्ष, शेकडो वर्ष ट्रेडमार्क वापरला येतो. जसं पाहिलं असेल हिंदुस्तान लिव्हर कमिटेड कंपनी आहे, अशा इंटरनॅशनल कंपनीज आहेत ज्या कंपनीज 200-300-400 वर्षापासून अस्तित्वात आहेत, परंतु दे आर युजिंग द सेम ट्रेडमार्क. दे आर नॉट making new because they are registered and they are renewing them after 10 years, so that they have legal right to use that trademark after that tenure also. But in case of patent, if we don't have any tenure to extend the patent after 20 years, copyright after 70 years, design after 15 years, and plant builder right after 15 years, any fees you can pay, but then there is no any provision of continuation of the patent long life. मग रिन्युअल करण्यासाठी किती फीस असते? पहिल्या 2 वर्षासाठी 0. जेव्हा पेटंट ग्रँट होतो तेव्हा कुठलीच फीस 2 वर्ष भरायची नाही. त्यानंतर 6 वर्षासाठी तुम्हाला वाटते पेटंट आपल्या नावावर राहावं, 2000 भरायचं. 10 वर्षासाठी राहावं, 6000 भरायची. 20 वर्षासाठी पाहिजे तर तुम्ही 20,000 भरू शकता. After the 20 years, after paying the 20,000 of fees, 20,000 fee, you cannot renew the patent after 20 years. Let us see the top ranker of the patents. China is the topper in the world. Second is US, and our India is on 7th rank. China always try to file the patents, try to grant the patent and produces so many small things, but they are patented, so it is ahead one from the world. If our India try to file more and more patent, our rank may be increased. Then what is the situation of Maharashtra? It is a proud thing is that Maharashtra is leading in the our country, which is filing most of the patents from all our states, other states. It's a proud thing. And MP is last one. So it's a proud thing that Maharashtra is filing more and more patent. As Dr. Shishak sir said that about the patents right at territorial rights, म्हणजे भारतातच एखादं आपण पेटंट दाखल केलं तर त्याचे अधिकार फक्त भारतातच मिळतात. बाजूला पाकिस्तानमध्ये किंवा बांगलादेशमध्ये जर कुणी काही ती वस्तू विकत असेल, डुप्लिकेट करत असेल तर आपलं त्याच्यावर काही चालत नाही अधिकार. सो दिस आर द टेरिटोरियल राईट्स अँड वी हॅव टू द राईट्स आर ओनली ऍप्लिकेबल इन द कंट्री इन विच इट इज फाइल्ड. मग आपल्याला वाटतं की बाबा 22 देशामध्ये आपण पेटंट दाखल करावं जेणेकरून त्या देशामध्ये कोणी डुप्लिकेशन करू नये. अशा वेळेला सरांनी जर सांगितलं पीसीटी नावाच्या पद्धतीने आपण इंटरनॅशनल फायलिंग करू शकतो. अनेक देशामध्ये आपलं पेटंट एकाच अर्जावर आपण फाईल करू शकतो. We have to take benefit of that agreement made by the India with other countries. We can file the international patent through one application. You can get more than 52 countries claimed with your patent. Now I would like to share a story of the copyright. जेम्स जेविड स्लटर नावाचा एक फोटोग्राफर आहे. तो फोटोग्राफरनी काय केलं, आपला कॅमेरा जंगलामध्ये लावला आणि नंतर त्याने फिल्म डेव्हलप केली तर त्याला असं दिसलं की एका माकडाने एक छान फोटो काढलेला आहे त्याचा स्वतःलाच. मग त्याने हा स्पेशल फोटो आहे म्हणून कॉपीराईट साठी कुठे दिलेलं होतं, विकिपीडियाला दिलं. विकिपीडियाने काय केलं, हा फोटो जेविड स्लटर नावाच्या व्यक्तीने दिलेला आहे, मग त्याला कॉपीराईट का देऊ नये, मग त्याला त्यांनी कॉपीराईट अलाउड केलं. मग तो जेविड स्लटरनं कोर्टात गेला. कोणत्या कोर्टात गेला, US कोर्टामध्ये गेला आणि सांगितले की हा फोटो त्या माकडाने घेतलेला आहे, त्या माकडाने घेतला असल्यामुळे मला कुठलाही कॉपीराईट त्याचा घेण्याचा अधिकार नाही. तो ऑटो फोटो जनरेट आहे आणि त्यामुळे म्हणजे माकडाने घेतला असल्यामुळे मला त्याचा अधिकार द्यायची गरज नाही. परंतु US कोर्टाने असा निर्वाळा दिला, अ मंकी कुड नॉट क्लेम कॉपीराईट. एखाद्या माकडाला कॉपीराईट घेण्याचा कुठलाही अधिकार नाही. त्याचं कारण असं की अधिकार मिळाल्यानंतर एन्जॉय करण्याची क्षमता त्या व्यक्तीत पाहिजे, तर तशी माकडात नाही. So that copyright or any intellectual property can be enjoyed with human thing. So no animals can get any intellectual property right. Let us see the next slide. There are 4 questions in my mind I would like to share with you. Let us see the first question on your screen. Can we patent coronavirus? ज्या कोरोना व्हायरसच्या मुळे आपण हे ऑनलाईन वेबिनार घेतोय आणि सर्व ऍक्टिव्हिटी ज्या महामारीमुळे जग सगळं हातबल झालेलं आहे आणि होतं, तर अशा या कोरोना व्हायरसचं आपल्याला पेटंट घेता येतं का, ही शंका आपल्याला येणं साहजिकच आहे. तर त्याचं उत्तर असं आहे की कोरोना व्हायरस कॅन नॉट बी पेटेंटेड. पहिलं कारण असं आहे की 1966 सालच्या पेपरमध्ये कोरोना व्हायरस आणि त्याच्यासोबतच्या स्पेशीचा उल्लेख लिटरेचरमध्ये आलेला आहे. दुसरं कारण असं आहे की कोरोना व्हायरस जीवजंतू आहे. काही वेळापूर्वी आपण सांगितलं होतं नो लाईव्ह ॲनिमल्स प्लांट्स कॅन नॉट बी पेटेंटेड बिकॉज दे आर नॅचरली बॉर्न. या 2 कारणासाठी कोरोना व्हायरस हा पेटेंट घेता येत नाही. आता जसं शीर्षक सरांनी सांगितलं की जे औषध आहे की जे की कोरोनावर चालू लागलं म्हणून त्याच्यावर पेटेंट घेण्यासाठी बऱ्याच कंपन्यांनी प्रयत्न केला, तरी सर्व जगातल्या ह्या ड्रग्स कंपन्यांनी असं ठरवलं की अशा कोरोनाच्या व्हायरस म्हणजे औषधावर पेटेंट दाखल झालं तरी त्याला पेटेंट ग्रँट करायचं नाही. खरं तर ड्रग्सला पेटेंट घेता येतं, मेडिसिनला घेता येतं, परंतु एक जबाबदारी म्हणून नागरिकांची जगाचं कल्याण व्हावं म्हणून पेटेंट या कोरोना व्हायरसच्या औषधाला पेटेंट देणं बंद केलेलं आहे. आता राहिले 3 प्रश्न आपण घेऊयात. कॅन यू पेटेंट युअर नेम? आपलं नाव आपल्याला पेटेंट करता येतं का, हा प्रश्न आहे. आपल्याला नाव आपलं पेटेंट करता येत नाही. नावाचं फक्त कॉपीराईट होऊ शकतं जर ते नवीन असेल तर. जुनं नाव पारंपरिक असेल तर ते कॉपीराईट होऊ शकत नाही. नावाचं सुद्धा पेटेंट होऊ शकत नाही. नवीन असेल तर कॉपीराईट होऊ शकतो. कॅन यू पेटेंट आवर डीएनए? डीएनए सुद्धा आपल्याला पेटेंट करता येत नाही. दिस इज अ नॅचरल वन. परंतु डीएनए चेन ब्रेक करून जर काही शोध लावला तर मात्र त्याला पेटेंट घेता येतं. कॅन यू पेटेंट युअर सेल्फ? आपण आपलं स्वतःचं पेटेंट घेऊ शकतो काय? आपण स्वतःचं पेटेंट घेऊ शकत नाही बिकॉज वी आर नॅचरली बॉर्न अँड वी आर नॅचरली प्रोग्रेसिंग. Thank you to all by listening here. I tried to finish it within particular time and stay safe. Also the images and the videos are highly acknowledged which I have collected from the internet. My duty is to announce that the videos and images used here are collected from the net. Thank you, sir. Thank you. सर व्याख्यान झालेलं आहे. हॅलो
Okay,
मॅडम.
Deshmukh madam. Go ahead.
देशमुख मॅडम. हॅलो.
येस सर.
Wait, sir. Madam,
Can I
present from can I proceed, sir?
Yes, sir. You can proceed. Yes, yes.
Sir, thank you very much, sir, for your elaborative and very knowledgeable lecture here. After this session, I will invite Dr. Dalve sir for to preside this session. Dalve sir, Principal Dr. Dalve sir.
Okay, thank you, sir. Okay, thank you, sir. सर्वप्रथम सर्वांचे स्वागत. सरांनी केलं ते अत्यंत साध्या भाषेत, सोप्या भाषेत आणि सर्वांना समजेल अशा भाषेत. त्याबद्दल त्यांचं सर्वप्रथम आपल्या तिन्ही महाविद्यालयातर्फे आपण स्वागत करूया. आतापर्यंत आपण जेवढे घेतलेले आहेत त्याच्यापैकी कितीतरी सोप्या भाषेत आणि विनंती समजून सांगितलंय की जे की ग्रामीण भागातल्या साध्यातल्या साध्या प्राध्यापकाला सुद्धा आता पेटेंट करता तो नवीन काहीतरी करू शकतो. त्यानंतर पेटेंट कोणत्या याचं घ्यायचं हे सुद्धा सांगितलेलं आहे. थोडंच म्हणावं लागतं सर, युअर पीपीटी वॉज सो इंटरेस्टिंग, ऑल्सो नाईस.
थँक्यू सर. थँक्यू सर.
आणि पेटेंट कसं घ्यायचं, कशाचं घ्यायचं, कोणाकडून घ्यायचं, त्यासाठी कोणाचा वापर करायचा घेऊ शकता. अनेक प्रश्न जे अनेक प्राध्यापकांच्या डोक्यात ते तुम्ही अगदी सोप्या भाषेमध्ये समजून सांगितलेलं आहे. जण तुमच्या बरोबर आता इथून पुढे डायलॉग करत राहतील, प्रश्न विचारत राहतील अगदी सोप्या भाषेमध्ये. इतके दिवस याच्या अगोदर मिळून या IPR वर वेबिनार घेतलेले आहेत, पण इतके सोप्या भाषेत आणि मध्ये कोणीच एवढं समजून सांगितलेलं नव्हतं. तर या तुमच्या पाठीमागं अनेक प्रश्न विचारत राहतील, त्याची उत्तरं तुम्ही देताल ही अपेक्षा इथं बाळगतो. आणि वेबिनार मध्ये सर्वजण सहभागी झाले आणि स्क्रीनवर तर इकडे हलवता आली नाही आम्हाला, त्याबद्दल खरोखरच तुम्ही जे काही PPT बनवण्यासाठी त्यासाठी परत एकदा तुमचं कौतुकच करावं लागेल. स्वागत करतो परत एकदा. आणि चांगले विचार मांडले, चांगली माहिती दिली त्याबद्दल परत एकदा धन्यवाद.
थँक्यू सर. Thank you, sir. Thank you. Thank you very your presidential address for this second session. Now, I would like to thanks from my side also to the Bedkar sir for giving very much talkative presentation, which was very much easy to understand to all the participants and all. So thank you, sir. Thank you for your enthusiastic and informative session. Really, your session was very informative and full of treasure of knowledge. It is like which we were very much unknown about this all the intellectual property rights. Thank you, sir. Thank you once again, and thank you for Dr. Dalve sir for his presentation address for this second session. Now I would like to invite Dr. Vittal Zaibhai sir from late Ramesh Warpurkar College from Soinpet for extend vote of thanks for this second session. Please, over to you, sir. Vittal Zaibhai sir.
Any instruction regarding feedback? Yes, no, ma'am. Any
Yes, sir.
regarding-
If yes, you have to fill all the participant. There is one instruction to all the participant. You have to link will be sent on the about the feedback. So you have to fill up the feedback, and after filling the feedback, you will get a certificate simultaneously. So please fill feedback form to all the participants. And now I think Jai sir is there for extend his vote of thanks for this second session.
Yes,
If he is
ma'am.
not available, I will
Yes,
carry.
Yes, yes,
It is
yes,
there? Okay, sir.
yes, yes, yes. Okay, thank you all, dear and very renowned personalities from my bottom of heart. At the outset, we are really privileged by the guidance of such enthusiastic personalities on this very beautiful workshop. On behalf of three colleges, Sri Pandit Guru Paradikar Mahavidyalaya Sirsala, late Ramesh Varpudkar College, Sonpet and Vasundhara College, on behalf of all three colleges and all three principals, my respected principal, Dr. Vasant Satpute sir, one more principal and my friend, Dr. Haribhav Kadam sir, and Dr. Dalve sir, and all three IQAC coordinators, Dhanve sir, Dr. Mukundraj Patil sir, and Dr. Deshmukh ma'am, as well as all colleagues and all renowned and great contributors. I really thankful on this beautiful platform, virtual platform. And finally, this is fourth time or fifth time I have listened Principal Dr. M.M. Bedkar sir from Kumaraswamy Mahavidyalaya Ausa. And really, though it is very difficult for art or for literary people to work for the patent, but it is very good opportunity for all science teachers. They can strive themselves for getting patent in their particular region or area. And again, on behalf of three colleges, IQACs and principal, I really thankful to all participants as well as the resource person principal Bedkar sir, and in permission of chairperson Principal Dr. Dalve sir, I conclude or I declare that this session is over. And now I hand over the mic to, specially I really thankful to, yes, one more, that Dr. Alka Deshmukh ma'am, who very skillfully handled the session. And again I handle mic to Dr. Alka Deshmukh ma'am. Thank you ma'am.
Okay, so thank you, sir. From behalf of my side also, thanks for all the eminent personalities, Dr. Shirsat sir, Bedkar sir, and all the participants. Thanks once again. And it's a invitation to all the participants that fill the feedback form to get your certificates for this national webinar. Thank you all. Thank you once again.
Thank you, madam.
Thank you very much.
आपल्या डॉक्टर HP कदम सर प्रिन्सिपाल SP शिरसाळा कॉलेज त्यांचं नाव घेतलं नाही. डॉक्टर
हरिभाऊ कदम हरिभाऊ कदम सरांचं नाव घेतलं, ऐकलं नाही तुम्ही?
नाही, मी घेतलं नाही सर, फक्त प्राचार्य एवढंच म्हटलं हे सांगतो. मला सातपुते सरांनी इन्व्हाइट केलं, आपण सर्वांनी इन्व्हाइट केलं, त्याबद्दल मी आपले सर्वांचे आभार मानतो आणि धन्यवाद.
थँक्यू.
ओके ओके बेटकर सर, थँक्यू बेटकर सर.
थँक्यू.